Hello, everybody. So Lady Di sent so many memberships yesterday. I thought I have to surprise her because of it. So yeah, I thought why not? Just let's surprise Lady Di. I didn't know this was happening today. To be quite honest with you, I saw it and I was like, you know what? Let's play it. But no one else seems to be playing it. It's the Colin Gray, father alleged Apalachee High School shooter. I don't really know. It's a hearing, it is. I know it's been delayed, so we'll listen into it. We're about an hour and a bit behind it, but it's all good. She is hot mama. How are you? Now, did you see my message in Discord? Hey, Mark, how are you doing, buddy? Hope you're well, my friend. Being like... being nice does get you somewhere. So, just to announce as well, we will be the next trial we're covering. I'm going to be all weekend. I'm going to be researching it. I've told Josie, but I'm not sure if she's seen it. But the trial is going to be Georgia v. Nicholas Kasotis. So the jury selection begins on Monday, and Kasotis is charged with a murder and dismemberment of his second wife, Mindy. And the YSL attorney Douglas Wee, or whatever his name is representing the defendant. So that's our next trial next week. So on Monday, I'll do a deep dive kind of thing to show the case, and we'll follow that. Hopefully by Tuesday, it'll start. I didn't know nothing either. Lady Di just found it, so I will deep dive into that over the weekend and stream probably Monday, and then hopefully it starts on Tuesday. But yeah, so that's the plan for next week. But we're not here for next week. We're here for today. So this is as I say, Colin Gray. Colin Gray is Colt Gray's father. Colt Gray was the one that shot one of the pew in the Apalachee High School. He's the Apalachee High School shooter. So this is his father who was arrested. He was offered bail, I think, of $500,000, but obviously couldn't afford that, so he's still in jail. But yeah, this hearing, I'm not really 100% sure what the hearing is fully about, but I thought I'd stream it because no one else seems to be streaming it. So here we go. I'll put it on now. We are behind by an hour 20. However, as I say, this is ad-free, so enjoy yourselves. We won't be interrupted. Also, I'll be zooming through as well. So without further ado, let me get it up. That's what she said. Oy. Right, here we go, everybody. Here we go. This is the judge has just come out, and they're going to get the defendant now. So here we go. Good morning, Terry. How are you? How are you, my darling? I'm always hard for you. Yeah, you are. They're waving opening. Yes, you are, Lady Di. But for those that maybe can't afford it or whatever, I will always try my best to do it ad free for people. So yeah, you are. But yeah, I hope everyone's well. Here we go, then, people.
I can give you like a synopsis of what's happening. If that would help, Your Honor. It's up to you guys. Your Honor, the day of the incident, Officer Bazinette and Townsend were directed to the residence of the person in custody, Colton Gray. They arrived, the body cam was on. Mr. Gray came out and met with him. There was an verbal interaction there. So we'll talk about the statements that were made there. There was a protective sweep when other officers arrived shortly thereafter of the house, came back out. At that time, Officer Bazinette also approached Mr. Gray, another exchange.
Cheating Stacy.
The state would argue at that point he gave consent to search the house. So that would be Officer Bazinette testifying to those two separate instances, one being the Jackson Deno issue, the other being the consent to search the house issue. Officer GBI Special Agent Janton is going to testify. He did the search warrant for the house. So he's going to testify about that. We're not doing the issue on the phone, Your Honor, because Agent Ward is the one that got consent to search his phone. However, since consent to search the house is an issue, we have the other GBI agent that was present when that consent to search the phone was given to talk about his state of mind and the consenting state of mind he was in at the time, but it goes towards the consent to search the house for this issue, Your Honor. And then the next day, he gave a statement to Jason Simpson. We have him to testify about that statement. So, Jackson.
Just want to address anything else. I'm sure the court will get the gist of it as we go. I don't think we're going to need to make any opening statement. Okay, thank you. All right, go ahead.
If you would raise your right hand, please. Swear the testimony given in the matter now pending before this court will be the truth, the whole truth, and nothing but truth, so help you God.
I do.
Okay, have a seat, please. And could you introduce yourself to the court?
Brandon Bazinette, deputy with Bexar County Sheriff's Office.
I want to take your attention back to September 4th of 2024. Where were you working on that day?
Yes. Well,
Where were you working on that day? What agency were you working for?
Bexar County Sheriff's Office,
And what was your capacity with Bexar County Sheriff's Office?
deputy.
Okay, and were you sworn?
Yes.
Okay. The morning of that morning, tell me about your morning.
I received a phone call about 10:45.
Okay, you normally work nights?
I normally do, yes.
Okay.
Received a phone call about 10:45. Let me know what was happening at the school. I got up, got ready.
Basically, what were you told about what was happening?
I was told that there was an active shooter.
Okay.
I got up, got ready. Responded code 3, license sirens. On my way to Apalachee, I was diverted to a different school.
Okay, so before you arrived, someone, or was it the radio, told you to go somewhere else?
Yes.
What was the purpose of you going somewhere else?
There was a possible threat at another school.
Okay, so possible other shooters?
We didn't get much detail. It was just there's a possible another shooter or some type of threat at one of the other high schools.
Okay, so which high school did you go to?
Winder Barrow.
Okay, and what did you do when you got there?
Once I got there, other deputies had already secured the school and made sure everything was okay there.
Okay, what did you do at that point?
After there, I was instructed to go to the nearby elementary school, just to make sure all the doors were locked, everything was secure there.
Okay, did you do that?
I did.
Okay. What happened when you did that?
While I was there, I was walking around the inside of the school and got a phone call from my lieutenant.
Where was he located at?
He was at Apalachee.
Okay.
Got a phone call from him telling me to get somebody to go with me and for me to go to this address and to meet you guy.
Okay, and did you do that?
I did.
Did you know why you were going to that address?
All I knew was we needed to secure the residence.
Okay. Did you know it was involved with this shooting?
I
mean, it wasn't there for.
No, I didn't know whose residence it was, how it was involved, but I did assume that it was involved with the incident.
Okay. And who did you get to go with you?
Deputy Townsend.
Okay. And did you go to that residence?
Yes.
Do you remember about what time you got there?
I don't.
Okay. Was it still that morning or?
It was.
Okay. And what happened when you arrived?
We get there. I go to the front door. Deputy Townsend goes to the garage. I knock on the front door. A brief moment later, Mr. Gray comes out the door in the garage.
Okay. And was Townsend there?
Yes,
Okay. And did you go and meet with him at that point?
I did.
Okay. And was there an exchange between you and you and Townsend and Mr. Gray?
Yes.
Okay. And did you detain him at any time?
No, he wasn't detained.
Okay. Did you put handcuffs on him?
No.
Did you make him get on the ground?
No.
Did you point guns at him?
No.
Okay. Your conversation with him, was it heated? Were your voices raised?
No.
Okay. Was it a calm
Yes.
conversation from your end?
Yes.
Was it a calm conversation from Townsend end?
Yes.
Was it a calm conversation from Mr. Gray's end?
Yes.
Okay. After you, and was your body cam on?
It was.
And have you gone back and reviewed your body cam?
Yes.
And was this recorded on that body cam?
Yes.
And was it accurate recording?
Yes, sir.
Your Honor, I'm going to tender State's Exhibit number 1. It's actually one jump drive that has more than one thing on it, but for the purposes of it.
Each one is the file, the clip that you're going to play first, is it?
It is actually the entirety of his body cam. It's about 30 minutes in length. The two separate clips are each 4 minutes, around 4 minutes each.
Any objection? Not for the purpose of this hearing. All right. Stage 1's admitted.
So once you've had an interaction, what are you doing at that point?
Once he comes outside, we are waiting for the GBI to arrive, or somebody else, so we can go do the protective sweep.
Okay.
We only have 2 deputies there at the time, so
Okay. And how quickly did other people arrive?
within a few minutes.
Okay. And did y'all do this protective sweep?
Yes, sir.
And what is a protective sweep?
Basically just checking to make sure there's nobody else inside the residence, no other threats or anything.
Okay. And did you do this?
Yes.
And were you part of the people that went in?
Yes, sir.
Okay. About how long did this protective sweep last?
Maybe 2 or 3 minutes at most.
Okay. When you came back out, where was Mr. Gray?
He was in the driveway.
Okay. And did you go and speak to him again?
Yes.
No, this is another one, Lady Di, another one. The sun will be done after this one.
Okay. And again, was he in restraints?
No, sir.
Okay. Was he free to walk around?
Yes, sir.
Okay. Did he have a cell phone with him?
Yes.
Was he able to make phone calls?
Yes.
Okay. Was he actually on the phone with someone when you came out?
Yes.
Okay. And did you speak to him at that time?
I did.
Okay. And what was the purpose of you speaking to him at that time?
I was just letting him know kind of what was going on. Didn't go into detail, just letting him know that we were waiting for the GBI to do their thing. And
Okay.
that was it.
Did you say anything to him about anything you had seen in the house during your protective sweep?
No.
Okay. And did he give you consent to search the house at that point?
Yes.
Okay. All right. This time we're going to show the second clip, which for purposes of the record starts at 20 minutes and 30 seconds and goes until 24 minutes and 15 seconds.
And just for the record, I think they're putting these two motions together, so I'm going to argue one portion of it. So
It's just
we'll split it up as we go. But it looks like a little strange. That's what we're trying to.
They've split up there. No issues. All right. So this is from stage 1, 20 minutes, 30 seconds to 24 minutes, 15 seconds. Is that
Yes,
right?
I think you need to turn it on your end.
Turn on your TV's already on, your computer's already on, is that right? Is this what you want?
Yes, sir.
Yeah, Mr. Gray there.
Yes. Yes.
So right now, all I can tell you, I don't know what he might have said, but they are going to get search warrants for the house.
That's fair. There ain't nothing in there for, I mean, if you just need, okay, y'all can go, you don't need a search warrant. There ain't nothing there to hide. And it's clearly he's got something to do with my son. I just want to make sure he's not hurt. Jesus Christ.
Who's in charge right now? You're him. Yeah, doesn't matter. Technically, Katie, she's sergeant. Mm-hmm.
Oh, Cosby, that's right.
Yeah.
What's your name? Oh, Colin. I'm sorry for the, I don't know, but I know it's bad, obviously, nobody will say anything about my son, well, just making sure he's not. Like,
Well, when we're gonna get some stuff figured out here before we can just talk to you. But somebody will explain the situation here in briefly.
Okay.
So
What's
just
the
bear with us.
It's my work phone number. It's 706-410-8447.
What's your son's name?
Oldest one is Colt, and my little boy, Colin Jr., is in elementary school.
Which
Austin Ray School. Austin Ray. Elementary.
Austin Road.
Yeah.
Is that in Maryland?
He's a rocket.
Okay. I went through here with Austin.
Yeah, he's undefeated, so boy.
Yeah.
Yeah, he's been fired now, so I'm fine.
is the youngest. He's
And at that point, you walked away from the
Yes.
defendant. Do you see the defendant here in the courtroom, Mr. Gray?
I do.
Okay, you pointed out to us.
He's wearing an orange and white stripe shirt.
Make the record reflect you pointed out on the defendant, Colin Gray. Now, did you ask him for consent to search his house?
No,
Okay. So, at any time, did he revoke that consent that he gave you?
not to me.
Okay. And what was his demeanor like while he was talking to you?
Calm.
Okay. Did anyone speak to him in a confrontational tone?
No,
Okay. And was he ever restrained?
no.
Just like. Nothing further, Your Honor.
Ms. Johnson, Mr. Perry? Yes, Your Honor. Good morning, Officer.
Good morning.
Just a few questions.
Mhm.
You indicated that you had gotten information from your lieutenant that you were going to go to this particular location.
Yes.
Is that correct? Did you meet your lieutenant there? Did you go pick him up? How did the two of you get together?
No, he was at Apalachee High School.
Okay,
Like I said, I received a phone call from him telling me to get somebody to go with me and meet GBI at this address.
okay. So you met him there at that location.
Not my lieutenant.
Okay, who did you meet there?
When we first arrived, it was me and Deputy Townsend, and then GBI showed up a few minutes after that.
Okay, we saw in the video that there were a number of officers there.
Mhm.
Is that correct? How
Yes.
many officers were there when the conversation is going on?
That I'm not sure.
Okay. We saw a number of officers had automatic weapons around their shoulders.
Yes.
Okay. Did you also have one?
Yes,
Okay. How many of the officers had that same type of automatic weapon hanging in plain view?
I don't know exactly how many. There were several.
Okay. And did your lieutenant tell you to do a protective sweep of the home?
It's standard when we secure a home I said, it's standard to do a protective sweep anytime we secure a residence
Well, what would be the reason to clear the residence?
to make sure there's nobody else inside. There's no other threats or anything.
Well, did somebody tell you that that was the scene of a crime, that home?
The scene of a crime? No.
Okay, so what would be the reason, because you don't normally, if you go to somebody's house to talk with them about something, you usually don't do a protective sweep, do you?
It's because of the search warrant.
I'm sorry,
Search warrant.
a third one,
A search warrant.
a search warrant.
Yes, sir.
Did you already have a search warrant?
No, I did.
Okay, so when you said I'm gonna do a protective sweep, there was no search warrant, correct?
Correct.
Okay, so you just, on your own, nobody told you, you just decided on your own that you would do a protective sweep?
To make sure there's nobody else inside the residence.
Okay, and was there any information that you had that would lead you to believe that anybody else was there?
I didn't know.
Didn't know. Did you ask Mr. Gray if there was anyone else there?
I didn't.
Okay, would that be reflected on the video?
Yes,
Okay, and did he say nobody?
he did.
Okay, but you decided to do the protective sweep anyway?
Yes.
Okay. And what did you see when you made the protective sweep?
There was nobody else inside the residence.
Okay, were you looking for anything else?
No, I'm looking for people.
Okay, didn't look for any weapons or anything else?
No, I'm looking for people.
Okay, so then you come back out. Did you have a conversation with Mr. Gray about what was going on at Apalachee High School?
What was going on at Apalachee?
Mhm.
No.
Did he appear to you to know what was going on?
He seemed to be aware of the incident.
Okay, aware of something, but didn't really know what?
Correct.
Okay, but nobody told him. You didn't tell him, right?
No.
Did anybody else in your presence tell him what was going on?
No.
Okay. And who was the person that asked him if it would be okay to search?
Nobody in my presence asked to search.
Okay, so you hear Mr. Gray saying it's okay to search, but nobody asked him? Is that right?
Correct.
Did anyone have any idea that at that point that Mr. Gray would be involved in the shooting at all?
No.
Were you given any information at all about who all was involved in the shooting?
No.
So you didn't know whether it was Mr. Gray's son or family member, or didn't know who, right?
Correct.
And at that point, did you When he said it's okay to search, did you actually search or did you go get a search warrant?
I didn't search. GBI got the search warrant.
Okay, so the GBI went and got a search warrant,
Yes,
and was that the same day?
I'm not sure.
Okay, so you didn't have any further involvement with it after that?
No, sir.
And did you have any conversation with the GBI about Mr. Gray consenting to
No,
searching the house?
no,
Okay, how did they know that he consented?
that I'm not sure.
So
I don't know.
you don't know whether they knew that he consented or not, right?
I don't know.
And they didn't consult you about what information they gave to the magistrate in order to get a search warrant issued?
No, sir.
And did you have any further involvement after this video?
No, sir.
This was a sum total of what you've done,
Yes.
correct? Okay. Do you have any idea who may have talked with Mr. Gray before you got there?
Before we arrived at the residence?
Before you got there?
No.
Okay. Were there other officers there before you got there?
No.
You were the first one?
Yes.
Okay. So the sum total of what had been told to him would be reflected on your video?
Correct.
All right. Thank you. Thank you. Yes.
Mr. Barry asked the questions I would ask, so we're fine. Can you redirect?
Yes, Your Honor, the redirect I would have would be about the contents of the first clip, and I don't think I put on the record, the first clip is from the beginning, 0000 to, no, it's from 1919, so 19 minutes, 19 seconds. I think the clip starts with him driving, him arriving at the house, and he gets out of the car at 19 minutes and 19 seconds, or excuse me, 9 minutes, 19 seconds, and goes to 13 minutes and 15 seconds. The redirect I would have of him would be the conversation that Mr. Colin Gray had with him during that, and I think we've agreed that you can watch that clip in chambers.
That's correct, Judge. Okay. So the two clips that are relevant for the issues that we have motions on today are 9 minute, 19 seconds, 13 minute, 15 seconds.
Yes, sir.
20 minutes, 30 seconds to 24 minutes, 15 seconds.
Yes, Your Honor. And the whole clip's about 30 minutes, if you wanted to watch the whole clip, but that's all that's able to present, Your Honor.
All right. Maybe come down.
Nothing further, Your Honor.
All right, yes, sir.
State would call Special Agent Janton to stand. Please raise your right hand, please. Swear the testimony given the matter now pending before this court will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Have a seat, please. If you could identify yourself to the court.
Special Agent John Janton with the Georgia Bureau of Investigation.
And I want to take your attention back to September 4th, 2024. What were you doing? What was your job on that day?
I was a Special Agent with GBI.
Okay. And are you what's referred to as post-certified?
I am.
Okay. And on that morning, what happened?
I was on my way to the office in Athens when I was notified of an active shooter at the Apalachee High School, and we were told that anybody that was available to respond, go ahead and respond that way. So I redirected down to the high school.
Okay. And did you make it to the high school?
I did.
Okay. What was the scene like at the high school?
It was very chaotic. When I arrived, it took me a few minutes to kind of get my bearings as far as where I was needed and what I needed to do. I found my supervisors, and we got together in the media center after the school had been cleared.
And basically, what have you been told about what had happened?
At that point, the only thing that I knew was there was an active shooter. We were going to be the agency responsible for more or less working the investigation of the crime scene, interviews, search warrants, and things like that.
Okay. And were you given an instruction of what you were going to be doing?
Yes, I was told to work on a secure and work on a search warrant for the residence of the shooter.
Okay. Had the shooter already been taken into custody?
He had,
Had he already been identified?
yes,
Had his residence already been established
Yes.
through the school?
Yes.
And was that given to you?
it was.
Okay. And so you were supposed to get a search warrant for that residence?
I was.
Okay. And did you go to that residence?
I did.
Tell me about that.
By the time I arrived, there were several other GBI agents and Barrett County deputies that were there. And I set up in the back of my Tahoe with my computer and started working on the search warrant.
Okay. And was the defendant present on the scene when you arrived?
Yes, he was.
Was he detained physically in any way?
Not that I saw.
Okay. And was anyone pointing any guns at him or anything like that?
No.
Okay. So you wrote a search warrant?
Yes.
Okay. Let me show you what's marked State Exhibit number 3.
You recognize that?
You recognize that?
I do.
And what is that?
This is the search warrant that I wrote that day.
And is that a certified copy?
Yes, it is.
Okay, Your Honor, Chair takes it number 3 in the evidence at this time.
Okay.
So you wrote the search warrant there, I think 6 in the back of your Tahoe.
Yes,
Okay, was that based on the information you gathered from other law enforcement?
it was.
Okay, and where did you take that to be signed?
Here at the courthouse.
Okay, and who did you go to see to sign it?
Judge Mingledorf?
Okay, and was he an active Superior Court judge in this county at that time?
Yes, he was.
Okay, and were you sworn in when you went to see him?
I was.
Okay, what did you tell him the search warrant was for?
I don't remember specifically what I said, but I gave him some kind of context as far as this is the residence of the school shooter, or this is the residence of Colton Gray, who has been identified as school shooter.
Okay, and did he ask any questions about anything?
We talked about the warrant. I don't remember specifically what he asked me.
Okay, it was all your information for probable cause that you had gotten in the affidavit written down in the search warrant?
Yes, it was.
Okay, and did he find that there was probable cause and sign the search warrant?
Yes, he did.
Okay, and what did you do with it at that time?
At that time, I would have made a service copy to leave with the residents, and I notified the agents that were on scene that the search warrant had been signed so they could begin the search. I made my way back to the residence to bring this copy of the search warrant.
Okay, so you went back to the residence with a copy of the search warrant?
Yes, I did.
Okay, and was the search of the residence executed while you were there?
Portion of it, yes.
Okay, were you involved in the execution or were you just there?
I was just there.
Good morning, Agent.
Morning.
Who did you get a telephone call from that morning? Initially, if you remember,
As far as
about the shooting at Apalachee.
it wasn't a telephone call. We've got an office, like a group text message for everybody in the office where we put information out, and it came through on that text message. We've got several agents in the office. So
And so where was your office located at that time?
Athens.
I'm sorry,
Athens?
Athens.
Yes, sir.
So you drove from Athens over to Winder.
No, I was somewhere between my house and the office in Athens. So I wasn't in Athens when
So you just veered on over here.
Yes, sir.
All right. When you got here, who did you talk to?
I believe the first person I spoke with was my ASAC, Heather Strickland.
And was he here or in the office?
She was here.
Okay. And was he at the high school or where was he located?
Yes, I met her on the football field behind high school.
And what information did you glean from that conversation?
At that point, we were told that the high school had been secured and that we were going to meet in the media center and start trying to figure out what our next steps were.
Okay. And who designated you as the one that would be getting the search warrant?
Jesse Maddox, the special agent in charge of our office.
Okay. And had you been given the information at that time where Mr. Colin Gray resided?
Yes.
Okay. And who gave you that information?
I don't remember who gave me the information.
Okay. And at that point, you proceeded to that location?
Yes, sir.
And when you got there, how many officers were there?
I don't know. There were several.
Did you have any conversations with any of the officers there?
Yes.
And who did you talk to there?
I spoke to specifically, I remember speaking with Special Agent Cameron Karate and Special Agent Andrew Steele.
Did you have a conversation with Mr. Colin Gray at that time?
No, sir.
Okay, never spoke with him.
Not initially, no, sir.
And did any of the people that you spoke with there, any of the officers or agents, did they give you any information about what Mr. Gray may have said before you arrived?
No, sir, I believe so.
Okay, so I understand then that the search warrant that you were writing out was based entirely on the information that you received while you were at the football field.
No, sir. The information in the search warrant was information that I gathered while I was at the residence from other law enforcement.
Okay, and what other law enforcement did you gather that information from?
I got some information from Special Agent Karate, Special
Okay,
Agent.
let's stop there. What did he tell you?
I'd have to look at the search warrant, remember specifically what he told me.
Okay, let me.
I had the original. certified copy.
Show you state's exhibit 1.
It's 3.
3, sorry, can't see.
Yeah.
Bad when you get old. Show you state's 3 and see if that refreshes your memory.
Agent Karate spoke to me about his role in securing the residence while we were waiting for me to obtain the search warrant.
Okay. Told you that he had made a protective sweep?
That's correct.
Okay. Anything other than that?
He discussed some of the items that were located in plain view during the protective sweep.
Okay, so he told you that he had observed other things while in the house.
Yes.
Okay, so he was looking for other things other than just people.
No, sir.
What did he tell you that he saw?
Pictures hanging on a wall and what appeared to be a letter on a desk.
Okay, did he tell you what was in the letter?
No, he did not.
Okay, who else? I'm sorry, go ahead.
It just that he noted at some point somewhere in the letter it was that Colt was asking for forgiveness.
Okay, so when you read a letter, you're not really looking for somebody, you're actually reading something that's laying on the desk, I guess, right?
I don't know what Agent Karate did while he was doing the sweep. This was just information he gave me, and
Okay.
based off a letter on the desk.
And who else did you talk with other than him?
I don't remember who I spoke with, but I got information concerning an interview that had occurred with Colin Gray. It was on the phone. I don't recall if it was Agent Janton or Deputy Smith that I spoke with.
Okay, and what was that information that you gleaned from the phone call?
It was information that they had gathered during the interview that was conducted with Colt after he was detained as part of the shooting.
Okay, was that something like his home address or something more than that? Do you remember?
It was information that he provided them as far as some context to the shooting and what he'd been dealing with personally.
Okay. Any other information that you got before the search warrant was issued?
Yes, I was told about the two deputies that arrived on scene and initially secured the residence.
Okay, so there were two other deputies on the scene
Yes.
and you talked to them.
I don't remember specifically if I spoke to them or if I received this information by somebody else that spoke to them.
Okay, and let me just be clear. Did you say that they had cleared the residence as well? Was it just one officer that cleared it, or were there 2 to 3 officers that went in?
I wasn't there when the residence was cleared. I just know that I was made aware of approximately what time the Barrett County deputies arrived at the residence and made contact with Mr. Gray.
Okay, but did any of the others indicate that they had gone into the house as well?
Yes.
Yes?
Yes.
Okay, and which other officers had gone into the house?
Special Agent Karate, Agent Rudisil, Special Agent Shear, Agent Walker, Deputy Bazinette, Deputy Townsend, Deputy Crosby, and Deputy Brazano, and Officer Hercules is who I have listed in here as one of the residents.
You indicated that after you wrote the search warrant, you came back to the courthouse and met with the judge.
Yes.
And you indicated to the state that you didn't remember exactly what you told them. Would it have been basically what you told us this morning?
It would have been the probable cause that was in that search warrant. Yes.
And what was that probable cause?
It was the items that I have listed in the affidavit here.
Okay, can you tell us what that is?
That we were notified, or that there was a 911 call placed about an active shooter at the Apalachee High School. That the shooter, Colin Gray, was taken into custody. That there was an interview conducted by Investigator Smith with Colin, and then that the deputies had arrived on scene at the residence of Mr. Gray, and that the residence was secured, and that I was, that was it until I obtained the search warrant. And
in the search warrant, did you indicate that you wanted to search the entire house or only the room that Colin Gray occupied?
The search warrant asks for the entire house, outbuildings and other structures within the curtilage, and any vehicles that were on the curtilage as well.
I know we talked about the vehicle, but did it include the vehicle?
Yes.
Okay. Do you remember any other conversation at all that you had with the with the judge before the issuance of the search warrant.
I don't.
And did you, I think you indicated to the state that you were there when the search actually started. Did you stay there the entire time?
I wasn't there when the search actually started. I called and let them know that the warrant had been signed. I was on my way back. But no, I did not stay the entire time.
Okay. Do you know whether the search had already started before you got there?
I don't.
Did you get any information later that the search had started once you phoned in that there was a search warrant?
When I showed up with the search warrant, the search was ongoing.
And I think it was your testimony that you didn't do any of the searching, is that correct?
That's correct.
And didn't take anything into custody that was found?
I personally do not know.
All right. This one's okay.
When you were talking about people that you want.
See if he has any additional questions.
Oh, I'm sorry. I thought you were going about this with us.
I can come back and ask away.
When you were talking about the additional people that had gone in the house before you got the search warrant, was it your understanding from them talking to you that they were going in individually, or was this all the one protective suite?
No, this is one protected suite.
Okay, so they were all participated at that one time.
That's correct.
Okay. Did you hear or see Mr. Gray tell anyone, I don't want you to go in the house, I don't want you to search the house, I revoke consent, or anything of that nature?
No.
Did you ever ask Mr. Gray about going in the house?
No, sir.
Okay. And nobody told you anything about Mr. Gray saying it was okay or not?
No, sir.
Thank you. Did you come down?
Yes, sir.
All right, thank you, sir.
I put a poll up as well to see what you think. I'm not putting the poll up to start an argument. I put it up just to see what people think. And you're interested in your thoughts.
You raise your hand, please. With testimony given, matter not pending before this court.
So, answer it honestly. There's no right or wrong. No one knows what you voted. So I'm just interested to see what you think in the poll. So now this is more of a beard, I think, ladies, that you can, it's more manageable, I think, for you. I think.
The truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir, I do.
Have a seat, please. If you could introduce yourself for the court.
My name is Investigator Jason Smith. I'm an investigator with the Barrow County Sheriff's Office.
Okay, and I want to take your attention back to September 4th of 2024. What was your employment at that time?
I was employed with the Barrow County Sheriff's Office, specifically their Criminal Investigations Division.
And were you what's referred to as post-certified?
I'm sorry, sir?
Are you what's referred to as post-certified?
Yes, sir, I am.
Okay, and were you on that day?
I was, yes, sir.
Okay. Tell me about what happened that morning.
We were contacted in reference to an active shooter at Apalachee High School. I responded there, code 3. Upon arrival, we conducted a security sweep of the school and began escorting students out of the school and rendering aid to those that were injured.
Okay. At some point, was the person who believed to be the shooter at the school, were they apprehended?
Yes, sir.
Okay, and did you have an opportunity to interview that person?
I did.
Okay, and did that person speak to you and give you information?
He did.
Okay, did you relay that information to your supervisors?
Yes, sir, I did.
Okay. Did you have any further involvement that day at the school?
Other than going back through with crime scene, no, sir.
Okay. Did you have any involvement at a residence with Mr. Colin Gray?
No, sir.
Did you have any interactions with Mr. Colin Gray on September 4th?
No, sir.
Okay. When was the first time you met Mr. Colin Gray?
I met him on September 5th at a forensic interview that was conducted with his juvenile daughter.
Okay, and where was that located at?
That is located at the Treehouse here in Barrow County at 173 Highland Drive.
Okay. Had you asked Mr. Colin Gray to go to the treehouse for that interview with his daughter?
No, sir, I did not schedule that interview.
And the interview was specifically for his daughter?
Correct.
And about how old was she?
I believe she was approximately 12 years of age, 13 years of age.
Okay. And where did you locate Mr. Colin Gray?
After the interview with his juvenile daughter, I made contact with him and asked him if he would like to speak with me at the Barrow County Sheriff's Office concerning his daughter's forensic interview.
Okay. And when you spoke to him, was your tone conversational?
Yes, sir.
Okay. Did you make any demands that he come speak with you?
No, sir.
Okay. Did he put up any resistance or say anything to make you think that he did not want to come speak with you?
No, sir.
Okay. Did he agree to come speak with you?
Yes, sir, he did.
Okay. And how far away is your office from the treehouse?
Maybe 100 yards.
Okay. And how did you get from the treehouse to your office?
I drove my assigned vehicle.
Okay. And to the best of your knowledge, how did Mr. Colin Gray get from the treehouse to your office?
He drove his vehicle.
Okay. Where exactly in the building did you have the interview?
We had it in a regular interview room.
Okay. And was this interview room, did he go in there and speak with you?
Yes, sir, he did.
Okay. Was he restrained in any way?
No, sir.
Okay. Did you order him about, I guess is the best way to put it, or,
No, sir.
okay. And when you went into this room, was the door locked?
No, sir.
Okay, did it ever get locked while you were talking with him?
No, sir.
Okay, and did he have a cell phone with him?
I believe he was using one of his juvenile children's cell phones.
But he had one with him that he could use? to
I
make
believe
calls?
so, yes, sir.
Okay, and is there a recording of what happened inside this room?
Yes, sir.
Okay, have you seen this recording?
I have.
And does it accurately reflect what happened in that court?
Yes, sir, it does.
Are there any material additions or deletions to it?
Not that I'm aware of, no, sir.
Now we're gonna have this as state exhibit number 2. It's on the same jump drive.
Any objections?
No objection.
All right, 2 submitted.
Did he agree to speak with you?
Yes, sir, he did.
Okay. And did you make any promises to him in order to get him to speak with you?
No, sir, I did not.
Okay. Did you give him any hope of benefit for speaking with you?
No, sir.
Did you threaten him with anything if he did not agree to speak with you?
No, sir.
Okay. How was the conversation as far as the demeanor of the conversation?
Much like you and I are talking now.
Okay. Did you ever get belligerent with him?
No, sir.
Okay. Did you ever raise your voice with him?
No, sir.
Okay. Did he ever get defensive with you?
Towards the end of the interview, yes, sir.
Okay. Did he ever get heated with you?
No, sir.
Okay. How old was the defendant at the time?
The defendant,
Yes, sir.
Colin Gray,
Yes, sir.
I would assume in his 50s.
Okay. Did he appear to be able to read and write?
Oh, yes, sir.
In fact, did he have a notebook with him that he wrote into?
Yes, sir, he did.
Okay. Did he appear to you to be under the influence of any drugs, narcotics, alcohol, or anything of that nature?
No, sir.
And in your training experience, have you been around people that are under the influence of drugs?
Yes, sir, I have.
Okay, so you would recognize it if you saw it?
I would.
Okay. Did he appear to understand the questions you were asking him as
Yes,
far as what you were asking?
Yes, sir, he did.
When he answered your questions, did they seem appropriate to the question you had asked?
Yes, sir.
Okay. And how long was this interview?
Approximately between an hour and a half and 2 hours.
Okay. Did he ever refuse to answer any questions that you asked him?
No, sir, he did not.
Did he ever attempt to leave the interview?
No, sir, he did
Did he
not.
ever attempt to end the interview?
No, sir.
Did the interview ever get heated or contentious?
No, sir.
How did the interview end?
I asked him if he was ready to go, and he said yes.
Okay. And what happened at that point?
He was placed under arrest.
Did you ask him any further questions after you placed him under arrest?
No, sir, I did not.
Your Honor, at this time, we're going to play just the beginning of the interview. So the clip is 2 clips, and I'll explain why. The first clip is 00 to 45 seconds, and it's basically them entering the room. Mr. Investigator, Detective,
It's fine. Investigator Smith is fine.
Investigator Smith, Detectives for Police Department, Investigator Sheriff.
Yeah.
Okay, I'm getting this right. Investigator Smith stepped out of the room and leaving Mr. Colin Gray in there for about 11 minutes. So we've taken that out. It's in, say, exhibit number 2, but it's not part of our clip. The second clip is from 10 minutes, 46 seconds to 20 minutes and 2 seconds. And it's him, Mr. Investigator Smith, coming back in and the beginning of their interview.
All right, so those are the 2 clips you intend to play?
Yes, sir.
Any objection to those clips being played?
No objection.
All right. You want the TV? Yes.
And then I'm gonna let you sit next door for a second. I'm gonna go grab my notes. I'll be right back with you, okay? You need anything? No, I'm good to go. Okay. I will be right back. I'm gonna lock the door until set it.
Yeah, it's all good.
You're right, this time we'll fast forward to 10 minutes, 46 seconds when Investigator Smith comes back in.
Okay. I apologize for that. I had not gone to the bathroom all day.
Yeah.
So I promise to wash my hands.
All good.
I'm going to introduce myself again. My name is Investigator Jason Smith. I'm with the Bergen Sheriff's Office.
Yeah.
And you're Mr. Colin Gray, correct? Okay.
Sorry, we're meeting like this.
No, yeah. Unfortunately, that happens. And I'm gonna apologize beforehand, because I'm gonna get 1,000 text messages and emails, and I'm trying to keep them, turn all them off right now. So I've heard a little bit, I understand you talked to law enforcement, I heard a little bit about, kind of your statements to him. I'm just gonna go ahead and explain my involvement. Yesterday, we were here at the office, we got a call. Go out to the high school, and while at the high school, after everything was secured, and you know, the medics assisted with life-saving measures and everything like that, I conducted an interview with your son. Okay, he did, you know, we respected his rights, he was read Miranda, you know, he was very respectful, yes, sir, no, sir, and he basically explained to us what he did. I mean, he explained to us exactly what we observed on cameras.
Okay, well, let me have it. What the hell did you say? Like, what happened?
Okay, so and I'll get into that and answer as many of your questions as possible. In order for me to kind of help better articulate that to you, because it's kind of like when you work a case like this, it's kind of like putting together a puzzle.
Yeah.
And right now, I don't have a very good view of what's going on.
Yes, sir.
So I understand he's been solely living with you for the past couple of years, give or take. And while we're talking, is it okay if I take some notes?
Yeah, I'm doing the same thing.
Okay, good. Because my memory, well, it's okay someday. Colin, you spell your name C-O-L-I-N?
Yes.
Okay. You have a middle name?
No, no.
No middle name. Colton didn't have a middle name either.
Yeah. Colton Junior, my little one that's 8.
He don't have a middle name either. Okay.
It goes back to my dad's side of the family.
Just no middle name.
All the boys, all the way back to the Mayflower. CG.
Wow.
And I was married when I was young, like.
I was wondering why everybody had that CG like
Yeah,
that.
so I was married when you're about to be 20 or whatever, you think you know everything. And moved out, got married, had 2 older daughters, Brittany and Brooke. And
You said Brittany Brooke?
Brittany and Brooke,
Okay.
yeah. And
Where do they live?
they live over in Woodstock with their mom.
Okay. How old are they?
They're 26 and 25.
Oh, okay.
So yeah,
Who's
so
26?
the older one's Brittany. Brooke is the younger one.
Well, why don't they have CG in their names? Just boys that?
That was just girls, yeah, so I told my dad, I said, it ended with me, Pops, I'm like, I'm really sorry, I have a whole lot of history, and he laughed, I'm like, I said, he was like, you'll be married again, boy, I'm like, you, well, man, you lost your mind, I said, child support, I'm like, do you want to go through this?
Then you got married again?
Got
That's where
married,
you can go, never say never.
and that's exactly what he said, I'm like,
Yeah.
I'm telling you, I can tell you where I was standing, what I was wearing, I said, never, and he was right, so got married.
Old people usually are.
Yeah, when I did the other side, I'm sure he's got a lot to say to me. We found out she was having a baby, I'm like,
Who's that baby?
soon to be ex-wife.
Oh.
Colt.
Who's that?
No, Colt.
Oh, okay.
And I said, oh my God, I said, first of all, are you sure it's mine? Just to correct you. Second was like, God, that was the boy. She's like, what do you mean? I'm like, no pressure, I said, I just like the boy. She's like, I'm telling you, son. She's like, oh. And find out later, she was like, I felt so much pressure to make a boy.
Yeah.
But, they're all 3 of them born in the same marriage and
But that ain't on her, that's on you to make boys and
I
girls.
know, and I just remember when I went in there, I'm like, where's my wife go?
Yeah.
She asked me to get water, and so I got to take her back. She had went in there and told the guy, turn it on, I need to know how to prepare myself, and it was a boy.
Was it?
And after it's all said and done, right, I walked in, I'm like, well, thanks for waiting. He's got these little egg over his belly, he's like, are you ready? And I'm like, yeah. He's like, okay. You know what that is? And I'm like, out the door down the hallway to the parking lot, call my dad, he was just dementia, colon cancer, it wouldn't take him over yet, but he could see right in the wall. So I was like, hang on, I'm trying to give him a carrot, like, you can, we'll push through this together because you're my grandson. Wow, he was just so happy, you know, Cole.
So you were only his only grandson?
Yeah.
So the very name was on, with you?
Yeah.
Wow.
Yeah, so.
Okay, well, let's get back to, which one's older, Brittany or Brooke?
Brittany.
Brittany's older. Brittany, is she gray?
She is great.
She is gray. Is she all right?
She may be divorced now, back to Gray, I'm not sure where all that stands yet.
Okay. Tom, what's your date of birth?
8/10/70.
8/10/70. And you have a telephone number?
I do, y'all got my work number, this is recently.
What do you mean, I got your work number?
Y'all got my work phone.
Oh, they're doing the, see, again, that's why I'm in here.
Okay.
I'm trying to put pieces up
Should
together.
have put, another GBI, but Agent Janton, just what we're doing right here, went through the whole thing. She's like, I guess this is my work phone and my work laptop.
Well, I'm sure they're gonna get that back to you.
That's what she said, and I'm like, okay, but I still need to let my boss know.
Yeah.
Like,
Were you able to let your boss know?
I was, Gmail account.
Okay.
And I just sent him an email and said, hey, I'll get back to you.
Yeah.
And like, his name's Kevin Preston, that happened, so he knows
How's that name sound?
because he's in the area, he's a good, go to church, go, man, we, you know.
What does he own?
He owns, Kevin Price General Contracting, and then,
Okay.
as I'm getting to know him, man, he's tied to a ton of stuff in Athens.
Yeah, that name sounds familiar. Kevin Price, General Contracting.
Yes, sir.
How long you been working there?
I started, beginning of May.
That's pretty recent.
Yeah.
What did you do before that?
I've done the same thing my whole career as commercial building superintendent. I'm in charge of building from dirt up high rises, hospitals, whatever.
Yeah, you just bring everybody together and make it happen?
They enter drawings and try to go back to that. So
Yeah.
that's what I do.
Your address, is that 896 Harrison Mill Road? Okay, I just want to make sure.
Yeah.
Go ahead and write that down. Before I write it down, I want to make sure that,
I'll do it.
you know how I don't know if you ever played the telephone game in school, where you start out telling one thing, and by the time it comes all the way back around, it's not even nothing.
Exactly.
That's one of the reasons that I'm in here talking to you.
Yep.
How long you lived at Harrison Mill Road?
It was a year this past June, we signed a 2-year lease.
Okay, lives in that house? What was the thing about Barrow?
This is where they were all born.
Really?
You know, they're off of Beach Creek Road.
Oh, yeah.
All except for local.
Yeah, I know.
We moved from Beach Creek and bought a farm in Salem, and that's really where we lived for the majority of our life.
Okay. How long did you live out at Beach Creek?
Oh, man, probably 10 years or so.
Okay.
8, 9, something like that. It was a long time.
Okay.
All the kids went, they started off at State Elementary and Helping Hands used to do that.
Your Honor, just for the record, the State Exhibit 2 is the entire interview. We've agreed that you can, if there's anything else that you want to look at or think about, or it comes up, can be brought up, we can look at it in chambers.
Right, that's correct.
Any other question, Your Honor?
Cross?
Yes, sir. Good morning, investigator.
Morning.
Just a few questions. If I
Yes,
ask a question that doesn't make sense or is ambiguous, let me know and I'll go ahead and try and rephrase it, okay?
Yes, sir.
All right. So let's go to September 5th of 2024.
Okay.
That would have been the day that you did the interview of Mr. Colin Gray.
Yes, sir.
Okay, just to kind of orient us to the same day. No, I believe that you testified earlier, you first encountered Mr. Gray, and just for the court reporter and everyone else, when I refer to Mr. Gray, I'm simply referring to Colin
yes,
Gray.
sir.
Okay. So you first encountered Mr. Gray at the treehouse for a forensic interview for his daughter.
Correct.
And you had conversations with Mr. Gray about meeting with you after that interview to do an interview of Mr. Gray.
That's correct.
And you asked him to meet you at the Barrow County Sheriff's Office.
Mhm.
Okay. And that's where you work out of?
Yes, sir. That's correct.
And you said it was about 100 yards or so from treehouse?
Yes, sir.
So real close.
Yeah, you can just about throw a football to it.
Okay. Maybe you can. So Mr. Gray drove over there by himself.
Yes, sir. He did in his
Correct.
vehicle.
Okay. And you were not in his vehicle with him or anything like that?
No, sir.
He wasn't escorted over by law
No, sir, he
enforcement?
wasn't.
Okay. When he arrives, are you there waiting for him or does someone else bring him back to the interview room?
I don't remember the answer to that question. I can go back and listen to some audio, but I don't remember
Okay.
if I answered.
So where in the Barrow County Sheriff's Office is this interview room located? If you could, best you can, describe that for me.
So if you're looking at the very front of the building, it's going to be on the right-hand side of the building. And it's located, that's where our criminal investigations division is. And it's located within that area.
Okay. So safe to say this is a private part of the building?
Yes, sir. It's a secured building. The whole building is.
Okay. So I or any other citizen couldn't just walk in and wander around this building?
Correct.
Okay.
You can get
So-
out, you just can't get in.
Okay. Gotcha. And I think I may have talked over, but you said you can get out, but you can't get in?
Correct.
Okay. Now, based on that, so someone from Barrow County Sheriff would have had to have taken Mr. Gray back to that interview.
Correct. I believe it was me, but I'd have to go back and double check.
Okay. And at any point during your interaction, it does not appear that you told Mr. Gray that he didn't have to do the interview. Is that correct?
No, sir. I just asked if he would do the interview and he said yes.
Okay. You didn't tell him that he didn't have to participate. It was totally voluntary.
No, sir. I didn't read him Miranda or anything.
Okay. Right. You didn't tell him that charges were being contemplated against him, for
No,
example? All right. And it appears that during the interview, you were wearing a sheriff's uniform.
I was correct.
Okay. And you would have had your sidearm
Yes,
with you during the interview?
Correct.
Did you prepare for the interview?
Yes, sir.
Did you review any statements prior to the interview?
I did not review any statements, but I did speak to investigators that had, with the GBI that had spoken to Colin previously.
Okay. Would that have been Investigator Ward, I'm sorry, Special Agent Ward, for example?
Yes, sir.
Okay. And during your interview of Mr. Gray, were there are other officers or agents able to watch the interview in real time?
Yes, sir.
Okay. And did that in fact happen?
It did.
Who was there watching the interview with you?
I believe it was a number, I can't tell you exactly, but there was a number of command staff that were watching from a closed circuit television room that we have set up.
Gotcha.
And I believe for a portion of the interview, at least, Special Agent Ward was there as well.
Okay. And the interview room, just for the record, appears to be about 10 feet by 10 feet. Is that fair?
Ish, yes, sir.
Ish. Okay. And there's a door that you testified earlier was not locked.
No, sir.
No windows in the room, anything like that.
No, sir.
And then there's a surveillance camera that allows you to video record and audio record the meeting you had in there with Mr. Gray.
Yes, sir. That's correct.
Safe to say there were other law enforcement officers present in the building that day,
Yes, sir.
also in uniform,
Correct.
also with firearms.
Yes, sir.
Did you, during your preparation for the interview with Mr. Gray, did you discuss possible charges or pending charges to be placed on Mr. Gray, not Cole?
Yes, sir. We discussed the potential depending on what he said during his interview.
Okay. Was there something specific you were looking for in his interview that would have been the linchpin upon whether or not to press charges?
Not any one thing, no, sir.
And those discussions were had with presumably Special Agent Ward, or
Yes, sir.
were there others in the command hierarchy you would have had those discussions with?
Yeah, I'm sure that my command staff would have known, my supervisor would have known as well.
Right, okay. And as you testified earlier, you never read him Miranda or had him sign a waiver or anything like that?
No, sir, he wasn't under arrest.
Okay. And you said he had a cell phone with him, but it may not have been his cell phone. Is that true?
Yes, sir. I believe that he mentioned possibly having his juvenile son's cell phone. I'm not 100% sure on that, but I believe he did.
And your testimony is at the beginning of the interview, there was no arrest warrant for Mr. Gray, Mr. Colin Gray.
That's correct.
At the end of the interview, was there a warrant for Mr. Gray?
No, sir.
Warrant hadn't been signed yet.
I don't know when the warrant was signed. I know that Special Agent Ward did go during that interview at some point and secure warrants.
So at some point during the interview, Agent Ward left to get the
Correct.
arrest warrant. Is that correct?
That's correct, but I was not privy to that.
Okay. And you're not sure at what point of the interview she left?
No, sir.
Okay. Can I have 1 second, Your Honor? Thank you. Investigator, that's all the questions I have. Thank you very much.
Thank you.
Can you redirect?
Just one brief, the stuff you talked about warrants being taken.
Yes, sir.
You found that information out after your interview?
Correct.
So you didn't know anything about it during?
No, sir.
No further question.
Can you recross?
No, Your Honor.
Thank you, sir.
Yes, sir. Thank you.
About yourself, you got it? I do. You can have a seat. Can you introduce yourself to the court and tell us what you do?
So my name is Amelia Maddox. I'm a special agent with the GBI, specifically out of our Atlanta field office.
Okay. And how long have you been a special agent with the GBI?
For 6 years.
And are you post certified?
Yes, ma'am.
Back on September 4th of 2024, did you become involved in the investigation into the Apalachee High School shooting?
Yes, ma'am, I did.
And how did you become involved in that?
So our Region 10 field office in Atlanta borders the Athens field office, which covers Barrow County. And we were requested by the supervisors to assist kind of an all hands on deck situation when it came out that there had been an active shooter.
And as part of your role in this investigation, did you have an opportunity to speak to Colin Gray?
I did, yes, ma'am.
And when and where did you do that?
Myself and Special Agent Kelsey Ward interviewed Mr. Gray in a vehicle in the driveway of his residence.
And did he voluntarily come to that vehicle to talk to you?
Yes, he did.
And was it one of y'all's vehicles, yours or Special Agent Ward's?
Yes, ma'am, it was Special Agent Ward's.
Okay. At the time you spoke to him, was he under arrest?
No, ma'am.
Was he free to leave at any point?
Yes, ma'am.
How long did that interview last?
It was about an hour and a half.
Was he calm and cooperative during the interview?
He was. He was very cooperative. He was emotional at times, just about the circumstances of what was going on, but he was cooperative throughout.
During the course of your interview, was the search of his house ongoing?
It was, yes, ma'am.
And during your interview with him, did he mention whether or not he was okay with people or the special agents searching his home?
He understood that we had a search warrant and that was going to be ongoing. I think at one point he said that his sister was a Las Vegas detective or somehow involved in law enforcement, and he was familiar with the process.
Did he specifically give consent during the interview to search his cell phone?
He did. Throughout the interview, Mr. Gray showed us text messages, like the last text message from Colt, some emails, and he consented to S.A. Ward taking photographs of those messages and pictures. And then after the interview was concluded, he signed a consent form for the cellular device.
At that point, did y'all take custody of the cellular device and have it downloaded?
I believe S.A. Ward, Special Agent Ward took custody of the device.
At any point during your interview with him, did he ever revoke consent to search his phone or to search anything?
No, ma'am.
Nothing for those.
Good morning, Agent Maddox.
Good morning.
You indicated that Mr. Gray had consented to you looking at his cell phone.
So he was consenting to Special Agent Ward taking pictures of his phone screen during the interview. He brought up text messages, some emails from a counselor, things like that, and allowed him to take photos.
Did anyone get him to sign any consent to search his phone?
Yes, sir. Agent Ward had him sign one of our consent to search a cellular device forms.
Okay. Did anyone ask him for consent to search his son's phone?
Not in our interview, not that I know of, sir.
Okay. From working the case, from what you know, did anyone ever ask him for consent to search his son's phone?
I'm not sure.
Okay. Do you know whether his son's phone was searched?
No, sir, I do not.
Did you know whether or not Colin Gray paid the bill for his son's phone?
I do not know that.
Okay. Nobody asked you?
I didn't ask him, no, sir.
Okay. These photographs that you or Agent Ward, Detective Ward took, those are in evidence.
I would believe so. Agent Ward documented the interview with Mr. Gray, so I'm unsure as to everything attached. But
All right. To your knowledge, was there ever a search warrant for Mr. Colin Gray's phone?
I believe there was, yes.
And do you know when that was issued?
No, sir, I do not.
And when you spoke with Mr. Gray, did you ever contact any other agents, especially agents that were attempting to get a search warrant?
I believe we let Agent Janton know that Mr. Gray had signed consent for his phone, but that was
What phone?
for his phone that he had. Yes, sir.
And what day was that on again?
September 4th.
And what time?
I believe it was at 3:06 p.m. But I think the exact time is on the consent form.
Okay. And you don't know when the search warrant for the phone was actually issued? Do you?
No, sir, I do not.
All right. That's pretty good. You redirect.
Member of the state, Your Honor.
Thank you. Not on the search warrants. Your Honor.
No, Your Honor, not on the Jackson, yeah.
So as far as the scope of what we've addressed today, no evidence.
Correct.
We still have the one issue that the court wants to get the development thing back in your chambers.
Yes. I do not have in my possession any of the evidence, things 1, 2, or 3. The search warrant was used by the agent testifying.
And due to the fact, Judge, that what you're going to be watching doesn't have anything to do with the search warrant, do you want to go ahead and argue that issue?
Yeah, I'm happy to hear whatever argument you want to make orally.
I would rather do all the arguments at once.
That's fine.
Be good. It goes to frame of mind. We're talking about voluntariness, which is a frame of mind of the defendant. So I think kind of want to argue them all together.
So we're going to resume the hearing for, I guess, the second statement, is that right?
Yeah, based on that, and I think based on some of what we heard today, I know Special Agent Ward is going to be testifying at a later time. I think that kind of ties into our argument on statement he gave to Investigator Smith. So I think we can just do arguments for everything at that time if that's amenable.
So you just want to argue to search the house today?
Well, if you want to do them all at once based on voluntariness.
No. I meant all of them that we're doing today. I didn't. We can argue Agent Ward's later. I'd like to do all the arguments today for what the issues we have today. I misunderstood.
Okay, some stuff in dispute. All right, so this is the father, Colin Gray. So he he could be on bond. The bond is $500,000, which means he needs to give $50,000 cash, which I presume he doesn't have, or needs to go to his defense. So he's still in jail. Sorry, Lady Di, your years. Because the video is down. Yeah, I don't know why. It's very low on their side. I don't know why the commentary is low. Hey, Dave. Dave T, Boston Laborers. Hello to you. I'm doing well. Hope you're doing well, my friend.
We're going to take a recess from you to review part of the evidence submitted to the new return to the argument.
So brief recess. Credible threats directly for the father. Not sure. Right, there is a brief recess. So what I'll do is I'll play the video that Just Irish just sent me, and then we will do it that way. So this is the body camera footage, the interview of Colt and his father. And then we'll get back to the hearing then. So this is body cam footage, 2023 school shooting online threat. Okay, so this is the body footage. Lady Di. No, I don't know when it's going to trial, Christine. No, I don't, my darling. Thank you, Christine, for your 23 months as well. He was in unloading dishwasher. Fine, okay. So here we go. Right, this is obviously, you can see this is Colt. I thought it was Colton for longest, but it's Colt and Colin there. So here we go. Hey, Carity. No, I believe it's been postponed. The trial has been postponed. There's been an issue with, I think, the attorneys. So I have seen this, but don't remember it. No, I don't remember either. I thought they moved him from our school. Wasn't his first day at the school? I generally don't know. Yeah, I think it's just been a decision that's just been made, I believe, from what I read. All right, listen to this first then.
Hey, how are you? Are you Colin? I am. You want to step out where you can talk real quick? You got a son or something that you know what Discord is? No. So we got a tip from the FBI saying that somebody from your old address over there in Traditions that made a threat to shoot up a school. For real? Yes, sir. And your name was associated with that address. So we went over to that address and you weren't living there. So now we live here. Let me get dressed. Sure.
Yeah.
Why is there a door in the front door?
Working nights.
Yeah.
I at least wear pajama bottoms when I answer the door. At least try to.
Come to the door in my underwear.
Unless it's in the middle of the night. I usually have a gun in the hand.
Yeah.
Gun in my hand.
Yeah, different story.
Yeah. Yeah. I had a thing over on Davenport Road.
Mm-hmm.
So just to confirm then, before we go any further with that one, oh, damn you, I can't move this. No, I can't move it there. Just to confirm with you then, so the trial has been postponed. New date has not been presented yet. The father faces 2 counts of second-degree murder, 19 counts of second-degree cruelty to children, and 2 counts of involuntary manslaughter and 4 counts of reckless conduct. The son faces more than 50 counts for murder, and aggravated battery to aggravated assault and child cruelty. So yeah, that's where we are. So there's no new date yet for the trial. It's been delayed, and that's why he was appearing in court today. Part of it, anyway. Okay.
Guy had stumbled through this person's yard, knocked on the door, dropped. When he left, he walked through a fence and tumbled into the ditch, lost his phone. So I picked his phone up, and it was one of those last calls. So I put it in an evidence bag, and I was like, and it was on the weekend, so I was like, nobody's going to be messing with this.
No.
So I put it in an evidence bag, forgot to take it by the office, went home. I had somebody showing up on my doorstep at 2 o'clock in the morning, beating on the door. Wife comes in there and like, hey, there's somebody at the front door. Went out there, they were gone, but I called Griff. He came out there and checked it out.
Sorry, boys.
That's all right.
Sorry, I got up watching the golf tournament and sat back down.
That was it. That was it.
Yeah.
So what? Tell me what.
You have any kids or anything, Luke?
Yeah, Colt Gray.
Colt?
Yeah, Colt. He's my oldest son.
How old is he?
He's 13.
Does he play a lot of video games and stuff?
Yeah, he does. Like all the time.
Is he here right now?
Yeah.
So, you think that's something he might have?
I damn sure want to know.
Can we talk to him?
Yeah, absolutely. Now look, he gonna get all red faced when you talk to him. Just calm. All right. So him and his. Let me give you a backstory. So we lived over at Traditions. I went to work one day. I'm sole provider. Build high rises downtown. So I get a call from one of y'all. So my family's in law enforcement. So when I get the call, I'm trying to think the officer's name. Turns out, nicest guy like ever. He's like, I just want to let you know I'm at your house. I'm like, for what? He said, y'all have been evicted. I'm like, no, I just paid rent. He's like, no. He's like, I'm going to stay here till you get here. So I drove all the way home. All my shit's in the front yard. And I'm like, what are you doing? He's like, I'll just let you know this is what's going on. There's people standing there with trailers and shit. I'm like, what are they doing? He's like, well, they're going to get your stuff after 24 hours. Is that right? Like, I don't even know why y'all are here. So, long story short, I'm like, trying to figure out what's going on with my wife. She's in the house. So we split. Long story short, for obvious reasons. She took my younger two and went back home, lived with her mom. Colt and I rented a house and came here. So we've been good, like no problems. He struggled first with the separation. All school was kind of so. So I've been up at school countless times, just tracking with him. You know, like, hey, make sure you're good. They understand what's going on.
He goes to Jefferson School?
He goes to Jefferson Middle School. Yes, sir. So he's been doing really good. Like, you know, in the beginning, he kind of struggled a little bit. But
let me ask you this: Do you have weapons in the house?
I do.
Are they accessible to him?
They are. I mean, there's nothing loaded, but they are down. We do a lot of shooting. We do a lot of deer hunting. He shot his first deer this year.
Yeah. Okay.
You know, so like I'm pretty much in shock, to be honest with you.
Well,
I'm a little pissed off, to be even really honest with you, if that is what was said. But
well,
we've been up to school for so many times now.
The information I got was sort of incomplete, and I don't know how old it is. And like I said, the original complaint went to your other address, or your previous address, and that's where we just came from. It wasn't them.
Yeah, no, I'm sure it wasn't.
I don't know if, and so we ran I had your name and date of birth, so
yeah,
that's how we got this address. So,
I mean, I swear to God, we've been up to school. I've been up to school, like, I'm on first name, but I just was up there 3 days ago for his finals, talking to the principal, like, look, make sure Colt's good. He gets flustered and under pressure. He doesn't really think straight. Can we just, just kind of put your arms around him, get him through 7th grade? I just want to make sure he's good. Like, I mean, we're up there all the time talking to school. Okay. If you talk to that school, they'll know exactly who I am. I'll say that. Okay. I mean, because I'm up there that much,
Checking in on him.
Yeah, sure. I just want to make sure he's good. Yeah. So I'm a little taken back by the whole thing, but I can tell you this, I take that very serious, and so does he, as a matter of fact. He's...
Say his first name's Colt.
Colt, C-O-L-T, yes, sir.
I mean, all I can do is ask him.
Yeah, well, absolutely. Yeah, I want you to talk to him and just tell him. Like, I don't know anything about him saying shit like that, and I'm gonna be mad as hell if he did. And then all the guns will go away, and they won't be accessible to him. I'm trying to be honest with you. I'm trying to teach him about firearms and safety and how to do it all, and get him interested in the outdoors. Mm-hmm. Like on my phone,
get him away from those video games.
Exactly right. That's the God honest truth. And the picture on my phone is him with blood on his cheeks from shooting his first deer. It was just the greatest day ever. Yeah, so he knows the seriousness of weapons and what they can do and how to use them and not use them. So it's kind of a little bit of a shock. So in whatever y'all are telling him, please instill in him that if this is whatever or wherever this is coming from, it's no joke. No. Like, it's no joke.
But we wouldn't be here if it was.
No, I know. And I'm telling you right now, we talk about it quite a bit. Okay. All the school shootings, things that happen.
Yeah.
Hey, are you getting picked on at school? He is. He's getting picked on at school. And is everything okay? That's why I keep going up there. Yeah. Because you never really know. And I don't want anything to happen to him. So. Mm-hmm. Yeah.
All right, well, if you want to grab them,
y'all talk.
Or we can go in.
It's all cool. Hang on.
That's the worst part about it. I don't know
what information,
These are good dudes. Just
hey, Colt, what's going on, bud? So did your dad kind of explain everything to you?
Said something about
shooting up a school.
Did you say something about school shooting?
Never. I just told him, I don't know what. Maybe they misheard somebody else. I would never say I would threaten them.
You never ever said.
No, I swear.
Do you use Discord?
Discord?
Yes, sir.
I used to. I don't have it anymore.
When's the last time you used it?
Like a few months ago.
Really?
Was it at Traditions or was it here?
No, it was at Traditions because in that Discord account that I had deleted it
before you moved here.
Yeah, because I think it got it been password pulled or something. Like I clicked on a link and somebody.
Have you heard anybody on Discord when you were using it say something like that? Remember?
Like at that time?
Yeah.
I don't think so. I don't think I ever had anybody that.
Never. And I mean, I'm not trying to get anybody hemmed up, but like this is some serious stuff.
Yeah, I know.
Oh, he knows how serious it is. Trust me.
Because I'd hate to. My boss was even like, I don't know how old this information is, and if you want to wait till Monday to follow up, I was like, nah, I'd rather do it now because.
So would we.
Because God forbid something happened and I didn't do my job. I'd feel pretty bad about that. So I just want to make sure you understand that if something like that happened or you hear something like that, report it.
Yeah.
Tell your dad, tell teacher.
Like I told him, I promise I would never say something.
So you haven't used Discord in a few months,
and
you're saying you didn't say anything like that.
No, the only thing I have is TikTok, but I just go around there and watch videos.
Okay. All right. Well, fair enough.
What's your birthday?
He's just gonna do a little report saying that
we
what
talked.
we done in reference to this, and that we talked, and you saying that we didn't say anything like that. And I gotta take you at your word, and I hope you're being honest with me. I'm not saying you're lying, but it's
serious thing.
It's not unusual for people to lie to police.
He's familiar with that too.
Hey, Colin, what's a good phone number for you, sir? Okay.
How's school going?
It's going good here.
About ready to get done with it?
I actually already finished.
Oh, you did?
Yeah.
When was your last day?
Let's say Sunday, so Friday.
Friday? What grade you going into?
8th grade.
8th grade, almost high school, man.
Yeah.
The last 4 years, really, the last 4 years is what matters.
Yeah. So I'm just focusing on
Get them good grades, man. It'll set you up for the rest of
Yeah, so look, you all are welcome any time. We take it like dead serious around here, and I just want to make sure that I'd even feel better if you do find out what or where. Like, can somebody let us know? 'Cause
Sure.
He's gonna be full of anxiety until this gets resolved. I can tell you that right now.
I've never really say something related to school.
So did you switch schools when you moved from Traditions? Where were you going before?
West Jackson.
West Jackson Middle? Okay. Is things a lot better now?
Oh, yes, sir.
Okay. That's good.
Let me grab you one. Can I walk through the grass? I'm gonna grab a card real quick.
Yeah, it's all good.
Are you getting bullied over there at West Jackson Middle?
That's the thing. I wasn't back there.
Oh,
I
yeah.
wasn't getting
Now, look, be honest with him about that.
Yeah.
Now in middle school, I told him you were now, and that's
You getting switched out halfway through the school year, being the new guy?
Yeah, I'm being that while. We moved like 6 times already. So.
Well, my dad was a logger and grew up in the military. We moved a lot when I was a kid.
Well,
So.
in the past schools, surprisingly, I mean, I had friends, like I didn't even necessarily have a reason that I would say that.
Yeah. Yeah. Well, there's always somebody you can talk to if you need to.
Yeah.
School resource counselors.
Yeah, and I do talk to them. Yeah, I talk to the counselor quite often.
Okay.
Just, let her update her on, stuff like that.
Yeah. Start looking out and making goals for yourself.
Yeah, I'll do that.
You interested in anything?
I want to be a philosopher. I want to grow up.
A what?
A philosopher.
A philosopher.
Yeah. It's kind of out there for me.
Yeah. Well, I mean, do what you enjoy. I mean, I did 20 years in the military. You don't have to settle on just one thing. Did 20 years in the military, retired from that, and been doing this for 7. So you don't have to fit everything inside the box.
Yeah, that might branch out to different stuff.
No. We got guys at the sheriff's office that are full-time plumbers, full-time police officers, and do what pays the bills. Do what they enjoy. But everything's going good.
Yeah, now, yeah. Sure.
No, that's good. You got a phone?
The iPhone, yeah, I have a phone.
What's your phone number?
Like I said, I changed my phone number.
Okay. All right. Dad said you went deer hunting for the first time this past year.
Oh, yeah.
What'd you get?
3-pointer.
3-pointer?
Yeah, it was nothing much, but I still.
Fork on one side and a prong on the other, or?
It was one on one side and 2, 3
Yeah.
So, yeah.
Yeah, fork on one side and one on the other. Spike.
Yeah.
Yeah. I've probably seen more one antler deer this year than any other time in my life. Out there in rut and breaking off an antler. Run around with just one set of antlers.
Grass about this high. So, anyways, all right. Well, look, Colton, I appreciate it. Your dad's got my card. If you hear anything, tell your dad. Okay, he's got my number. You pass the info on.
It's serious. He knows how serious it is, and he'll, like I said, we'll have a long conversation here in just a little bit. And if something You know, it's a pretty traumatic thing that him and I both went through. Now he was at school, I was at work, come home, and I mean every ounce of what we had was under tarps and sitting in that yard. You saw it.
Yeah.
You saw the clientele, the neighbors that lived there. It's like fully embarrassing. So it was
I
very traumatic for both
Sure.
of us. And living here, just us, is like the dust is finally settled. He's making good grades. So
That's good. We'll keep that up.
and
That's important.
we'll start talking about traditions in West Jackson and just see if something jogs his memory like that. But certainly we'd like to know if you do find.
Well, my thing is this. So more than likely they track the IP address.
Okay.
And that's why we went to that address.
Okay.
Because the IP addresses are usually location specific.
Yep.
You know, within an area. So if it came from that house, then either somebody there is lying or the information is just so old.
Yep.
And, you know, maybe it was something he heard or did on Discord months ago. I don't know. I have no idea.
Okay.
So, but he's telling me he didn't.
Yep.
Telling me he can't remember anything like that. And
Yep.
I take you at your word. Okay. If you look me in the eye and you tell me that's what you're telling me, I got no choice but to take you at your word right now. Okay.
Yes, sir.
But like I was telling your dad, if we find out otherwise, then it's a different story. Okay.
It's a really different story. Okay.
Got any questions?
No, sir.
You have any
Good guy.
questions? All right. I'll enjoy the rest of your day.
Thank you.
Appreciate it.
Appreciate it, sir.
Y'all be safe.
Good luck to you.
We'll knock out a report. You want me to?
It don't matter. It's just going to be an information. Our agency assist made contact with these people. They had no idea. The husband said that he hasn't been on Discord and since fantasy football. And,
Yeah.
And then Colin made contact with him and then brought his son, got his date of birth, brought him out, spoke to him. Apparently he was getting bullied. Very soft-spoken, reserved kid.
Yeah. Pretty much unable to substantiate anything at this point.
No.
So. And until we get more information from
I
this
got-
so-called tip from the FBI, then I don't know.
We got Dad's phone number, so we'll just do an agency assist report for the FBI and write it up and we'll be done.
Sounds like a plan to me. I appreciate you helping me out, man.
Hey, no worries. You take care of it. You need the case number? You got it. You need the case number? You got it. Okay.
There you go. Oh, and then, yeah, softly spoken, and then we are here. There's a lot to this case that we don't know yet, obviously, so we will have to do a deep dive on it. Right, let's get back to the hearing. There's a little bit left of the hearing. I'm trying to find it now, where roughly it is. It's about here. I'll start from here. I'll zoom from there then. Right, bear with me. I will add it back in here. Whoops. Parents can only do so much. You try and instill the best for your kids and teach them right from wrong. After that, it's on them to do right. Yeah, I totally agree with you. I totally agree with you. And I see the comments about like where does the line stop and stuff. I agree. You know, it's a dangerous precedent. So sad. I agree, Cara, as well. Oh, should parents of teens that drive while texting go to prison if they know they have a cell phone and lend them the car? And they, well, this is what we're saying. It's opening a can of worms, isn't it? You know. She's shooting happening every day in Milwaukee. There are no negligent parents in those cases. Yep. Right. I know. It's all a horrible situation. Right. This is them. I'll zoom to get them back. Slippery slope, slippery doo-dah, slippery doo. Ba, ba, ba. Colton is 14, yes. 14. Oh, it's not an accident. It's just whether you know, you should pour the blame on parents. I think, you know, he's obviously, if he did all this, then as a 14-year-old, absolutely, you know, it's just where do you draw the line on parents? Where's the responsibility lie? So, I mean, I've not seen anything in this case, so I'm going totally blind in this. There might be something glaring here that they did, but I don't know. I think I would want to watch the whole trial to understand the whole evidence against the father, I suppose. Right.
They call the office. Always a problem when you're not there. All right, we are all present. Let me remind the media, so you can only record or stream when court's in session when I'm on the bench. So if I'm off the bench, there shouldn't be a recording. All right, and let's make sure it's clear for everybody. What are we going to argue today?
We're going to argue a lot, Your Honor. We're going to talk about the statement to Bazinette, the consent to search to Bazinette, and the search of the house, search warrant.
All right. Y'all agree? That's what we're arguing?
I think so, yeah.
Yes, sir.
Go ahead.
Your Honor, starting with the consent to search, starting with the statement to Bazinette that you looked at, the issue comes out as the voluntariness. Matthews versus the state, 311, Georgia Supreme Court case 531, 2021 case. In that case, Your Honor, said that in determining whether a defendant's statement was voluntary as a matter of constitutional due process, a trial court must consider the totality of the circumstances, and the state bears the burden by preponderance of the evidence that the statement was voluntary. Under Dean versus the state, 292 Georgia Appeals, 695, 2008 case, Your Honor. And basically that case says that regardless of the custodial or non-custodial nature of the interview, for statements to be admissible, they must be voluntary. They are admissible if considering the totality of the circumstances. They were made voluntarily without being induced by hope of benefit or coerced by threats. If you watch the video, which you did, there was no hope of benefit given by Bazinette or Townsend, and that he was not coerced in any way by any threats. Under Troutman versus state, Your Honor, which is another Supreme Court case, that's going to be 300 Georgia 616. This is a 2017 case, Your Honor. And in that one, Your Honor, when it's talking about the hope of benefit or coercive threats, when it's going into the voluntariness, he's really referring to coercive police activity is a necessary predicate to the finding that a confession is not voluntary within the meaning of the Due Process Clause of the 14th Amendment. The circumstance of the investigation and arrest in the case reveal none of the extreme tactics identified as the hallmarks of coercive police activity, offensive to notions of due process, such as lengthy interrogation. This was less than a 4-minute conversation. Physical deprivation. He was not restrained physically in any way. Brutality or deception. None of that was in this case, Your Honor. These are techniques and methods which create circumstances in which the suspect clearly had no opportunity to exercise a free and unconstrained will. In these statements they gave, Your Honor, it's obvious that none of these tactics were used to be coercive, to override his free and unconstrained will. In fact, if you look at the jury instruction on voluntariness, which is 1.32.17, this is the law that's given to the jury about voluntariness. It says to be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestion or promise of leniency or reward. A statement made to induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. In this case, he's not in custody. He's at his own house. He's not restrained. The guns are not pointed at him. Any sort of restraint, verbal restraint on him, are all phrases that connotate temporariness. I think the phrases used are not to leave at this moment, emphasizing at this moment. He says, we're going to wait here until we get one more. Until we get one more. He asks, can I use my phone? And Townsend responds, give it just a minute. All these things connote a temporariness to it, not you are in custody. You have not formally been arrested, which is what is necessary for that to come about, Your Honor. A person is deemed to be in custody requiring Miranda warnings before interrogation when he is formally arrested or restrained to the degree associated with a formal arrest. In this case, Your Honor, there was no restraint. One of the cases directly on point is Owens v. the State. This is going to be a Court of Appeals case 332, Georgia Appeals 525. This is a 2015 case, Your Honor. In Owens, Your Honor, he is a visitor at a house that is being searched. He was actually being lawfully detained in the living room of the house while officers conducted a search of the common areas of the house pursuant to a fourth waiver and a probation order pertaining to his housemate. So the housemate had a fourth waiver for the house. He was actually detained in the living room of his house while they did that. He had not been formally arrested and was not handcuffed. A reasonable person in his position would not have thought that the detention would not be temporary. A person being detained is in custody only if a reasonable person in his position would not have thought that the detention would not be temporary. Also, there's a statement in Owens, another statement, that was not the product of interrogation. They said in Owens that in that case, the statement about knowing this was going to happen was not the product of interrogation in this case. It is unprompted and unsolicited. The last words out of Townsend's mouth is, we're going to wait right here for backup. No questions were asked, and then the defendant, unprompted, unsolicited, made a statement. He wasn't even saying the statement on the video. He's not even saying it to the police officers. It's more of an exclamation as he's walking away from them. He says this. So it's completely voluntary. Owen states that Owen did not make the statement in response to any questions, but instead volunteered the statement while two officers were searching the bag and talking to each other. Miranda would not apply to such an utterance, even if Owens made it while in custody. A defendant's spontaneous, voluntary, unprompted utterance to a police officer is admissible against him at trial. Do you want me to go through all the arguments or back and forth for each one? That's for the statement to Bazinette.
I mean, I'd probably prefer hearing it back and forth.
Okay.
Unless that presents an issue for y'all.
Just not none.
So Judge, we would agree with the state regarding the whether or not the statement was voluntary does depend on the totality of the circumstances. And the voluntariness goes to the course of police activity as a necessary predicate to finding that a confession or a statement is not voluntarily or freely given within the meaning of the due process clause of the 14th Amendment. So when you take into account the totality of the circumstances surrounding these two brief statements that Mr. Gray made to Officer Bazinette, the circumstances are such that whether he knew they were temporary, whether he knew the detention was temporary, hasn't been shown. What has been shown is that he was under the belief that he was not free to go, that he was not free to use his phone, that he had been escorted from his home, moved to the outskirts of the property away from the home, and that he had been surrounded, as you can see from the video, by many agents, what appears to be over 10, 12 agents or law enforcement officers in tactical gear with automatic weapons slung around their shoulders. So the question becomes, in the totality of those circumstances, is that enough for coercive police activity such that it overrides the voluntariness of any statement that he's given? And we would argue, just for purposes of these two statements given to Officer Bazinette, that it is, that based on his being told he cannot leave, he cannot use his cell phone, and being surrounded by agents in tactical gear with weapons, that does equate to coercive police activity, which is the predicate to finding those statements not voluntary given, and we would ask the court to suppress those two statements given to Officer Bazinette as not being made voluntarily.
Any final word on that?
I do, Your Honor, but it blends into my next argument, which is that I was arguing the first statements of the Bazinette, and he was arguing both statements. The second one is just a consent. It's not a statement. It's just straight consent to search, which goes into the voluntariness. Again, you're looking at the same issues, the voluntariness of it, when he made that second statement. So it will be a rebuttal to the first, and it is my argument for the second one. My main case on that, Your Honor, is Brooks versus the state. This is a Supreme Court case decided in 2009. I'm sorry, 285 Georgia 424. In that case, Your Honor, it is well settled that a valid consent to search eliminates the need for either probable cause or a search warrant. So my next argument is going to be about the search warrant, but this consent eliminates the need for that argument at all. You don't need that search warrant. It doesn't matter. They talked about that wasn't the consent from Bazinette wasn't conveyed to Agent Janton, but there's nothing in the case law that says the consent has to be told to every single officer. But because he consented to the search, that eliminates the need for either probable cause or a search warrant. Now, the state has the burden of proving that the consent was freely and voluntarily given under the totality of the circumstances, the same as the state we talked about earlier. And in that case, Your Honor, there was nor is there evidence of coercive police activities. The uncontroverted testimony of the officer who conducted the search showed that Brooks was cooperative, even friendly towards him, and offered to assist him in locating the gun. There is no allegation that Brooks's age or level of intelligence rendered his consent involuntary. There is no showing that the officers misrepresented their authority to enter and search against Brooks's will if necessary. In that case, Your Honor, you can see that all the talk with the defendant is friendly, courteous. There's nothing in there that shows any sort of lack of cooperation. Batten versus the state is the next case, Your Honor. That's going to be 341 Georgia Appeals 332, the 2017 case. In Batten, Your Honor, the voluntariness of consent is determined by the totality of circumstances. No single factor controls. The standard of measuring the scope of a suspect's consent under the 14th Amendment is that of objective reasonableness. And in that case, in Batten, Your Honor, there were several officers on the scene at the time. The defendant was not in handcuffs, and there was no evidence he was threatened, misled, or subject to lengthy detention. And that is exactly what we have in this case, Your Honor. That case also quotes Smith versus the state, which I don't have a copy of, but it's in Batten, which is 165 Georgia Appeals 333, a 1983 case, where consent was voluntary when the defendant was initially ordered out of his car at gunpoint, but police were no longer pointing weapons at him when he was asked for permission to search the vehicle. So even pointing the gun at you, as long as you're not pointing the gun at them when they give consent, something that overcomes your will to voluntary consent. And if you watch the video, there's nothing in there at all, Your Honor. Still in part, that the facts of our case, Your Honor, there's no duress. It's his home. There's no detention. Any words about stopping his freedom of movement implied it was temporary. It was in the first 4 minutes of their encounter. And it's just, hold up a second, wait a minute. We're just waiting for people to get here. And it's just trying to hold the status quo. This was a day. This was a crazy day. Everyone testified. They're running to this school. They're running to that school. They're running to this house. It was a day. These officers are there. Everybody just hold still for a second. And there's nothing that an objective person would think, oh, I am detained. I am been tortured. I have been threatened. I have been tricked. And therefore, I have to test. I have to give consent. There's nothing evidence of that, Your Honor. He was 53 years old. He had a job as a construction supervisor. His intelligence is not an issue. Everyone was being extremely cordial. We let the video play because there's a lot of talk about these officers with guns. We let the video play to show the interaction with some of these officers. Oh, your son goes to elementary school? Which one's that? Oh, is that here? And he's like, yeah, he's a rocket. He's the tug of war champion. And they're smiling at each other, shaking hands, being pleasant, being cordial. This was a completely voluntary encounter, and his consent was voluntary. It was never withdrawn or revoked. He kept consenting over the next 2 days. I know that the consent was given after this protective sweep, and a lot will be stated about the protective sweep. It's also on the video. All of this happens directly before the protective sweep, Your Honor. And Williams versus the state, which is a Supreme Court case, Your Honor, and that was decided in 2017. And that is 302 Georgia 474. In that case, Your Honor, a cursory warrantless search limited to spaces where a person may be found, known as a protective sweep, is permissible when officers reasonably believe, based on articulable facts known to them at the time together, with rational inferences drawn from those facts, that the sweep is necessary to protect or preserve life or to avoid serious injury to officers or others because of the potential presence of other dangerous persons or additional victims. We also have State versus Brennan, Your Honor, which is Court of Appeals case from 1996, 222, Georgia Appeals 372. And in that case, Your Honor, exigent circumstances allowed police arresting a suspect inside a home to make a cursory search of the house based on a reasonable belief that another occupant of the house might present an armed threat, upholding such a protective sweep to detect any immediate danger. Although we review police actions from the standpoint of a hypothetical reasonable officer, we must measure those actions from the foresight of an officer acting in a quickly developing situation and not from the hindsight which judges have benefit. And that's reiterated in Nelson versus the State, which is Court of Appeals 2005 case 271, Georgia Appeals 658. In that case, Your Honor, although we review police actions from the standpoint of a hypothetical reasonable officer, we must measure those actions from the foresight of an officer acting in a quickly developing situation and not from the hindsight of which judges have the benefit. Again, Your Honor, in this case, Bazinette and the other officers that testified, there's an active shooter at Apalachee High School. Everyone jumps in their cars. They are getting to Apalachee High School as quickly as possible. They're then diverted to Winder Barrow High School, where there's a threat of some sort of violence at Winder Barrow High School. They then divert to Winder Barrow High School and do a protective sweep there to make sure everyone's safe. They're then diverted to the elementary school, Bazinette testified to check on the elementary school, make sure everything's fine there. Then he's diverted to this house, Your Honor. This is a fast moving, developing thing where lots of information is coming into these officers about threats and shootings and danger, and they do a protective sweep at that time to make sure there's no other people in the house. If you go back to Park versus the State, Your Honor, which I've already given to you, when it's talking about the consent, Park versus the State also says, even assuming the illegality of the initial entry and search, so even if you find the protective sweep shouldn't have happened, a party's subsequent consent to the search, which is freely and voluntarily given, may serve as an independent act of free will that purges the primary taint and authorizes admission of the evidence. The more apt question in such a case is whether granting establishment of the primary illegality, so granting that it was not supposed to happen, the evidence to which the instant objection is made has been come at by exploitation of that illegality, or instead by means sufficiently distinguishable to be purged of the primary taint. So what it's saying is, even if you find that the protective sweep shouldn't have happened, the consent after that cleans that, as long as they didn't use that to get the consent. And in the video, he comes out of the house, he's on the phone with someone else not on the scene. No one says anything about what they saw in the house. Bazinette just walks up to him and says, hey, just to let you know, someone will be here to talk to you. We're getting a search warrant. And he voluntarily, without being asked, y'all don't need a search warrant, you just go on in. We got nothing to hide. The protective sweep had nothing to do with him volunteering this voluntary consent. It's hard to say that you were coerced into consenting by law enforcement when no one in law enforcement even asked you to consent. You just volunteered it. Volunteered, root word, voluntary. Do you want me to argue the search warrant now or come back? You have a preference?
You all have a preference? Go ahead.
With the search warrant, Your Honor, same issue. You got to remember that with the consent, you don't even need the search warrant. But under State v. Palmer, which is a Supreme Court case, 285 Georgia 75, 2009, basically just gives the standards for what we're looking for when we're reviewing search warrants. And it basically says we begin by reiterating the standards applicable to the various levels of judicial scrutiny involved in the warrant process. The magistrate's task in determining if probable cause exists to issue a search warrant is simply to make a practical, common sense decision, whether given all the circumstances set forth in the affidavit before him, including the veracity and basis of knowledge of persons supplying the hearsay information, there is a fair probability that contraband or evidence of a crime will be found in a particular place. The trial court may then examine the issue as a first level of review, guided by the 14th Amendment, strong preference for searches conducted pursuant to a warrant, and the principle of substantial deference must be accorded a magistrate's decision to issue a search warrant based on a finding of probable cause. Although in a particular case, it may not be easy to determine when an affidavit demonstrates the existence of probable cause, the resolution of doubtful or marginal cases in this area should be largely determined by the preference to be accorded to warrants. So when the warrant's signed, the trial court, when you're reviewing it, are supposed to give a strong deference, a substantial deference to the magistrate's decision. And you're also to keep in mind, this is under State versus Palmer, keeping in mind that affidavits are normally drafted by non-lawyers in the midst and haste of a criminal investigation, which is exactly what we have here. This is not something where officers have been investigating this case for months and weeks and finally decided to go do a search warrant. This is happening quickly, unfolding, chaotic, and that's where this affidavit was drawn, Your Honor. But the affidavit is perfectly adequate. It states there's a shooting at the school. The suspect was identified as Colton Gray. He had been feeling depressed, made a list of mental health issues. He said in the statements in the affidavit that he wrote down his mental health issues. That's a writing. The writing wasn't found on him. It is reasonable to assume the writing would be at his house that he had left earlier that day. He had discussed plans on Discord. That's a computer program, computers. He's discussing his plans. It's perfectly reasonable to assume there's evidence of that, evidence of motive, evidence of scheme in a computer in the house. He stated that he researched shootings on his computer. Again, on the computer, evidence of what he's been doing, his motive, his state of mind, all of that is evidence that officers can go in there and look at. And the defendant was at the residence when the officers arrived and stated he was Colt's father, stated there were multiple guns in the house. Again, this is evidence they can use to then probable cause to go find boxes of ammunition that match the ammunition found at the scene. Gun cases that match the gun found at the scene. Similar magazines that match the magazines found at the scene. All of this is reasonable to assume that this evidence would be at that location. Under Franklin versus the state, Your Honor, I don't have, yeah, I have copies of this. This is 135 Georgia Appeal 718. And it basically just says that oral testimony can be given. The very last sentence, the oral testimony was sufficient to fill the deficiencies in the affidavit, and the trial court properly overruled the motion to suppress the evidence seized in the search resulting from the issuance of the warrant. Officer testified that he swore to the magistrate, which was actually the Superior Court judge in this case, that this was the residence of the shooter who was in custody, and then that goes with the affidavit of what they found. Again, Watley versus the state also talks about oral testimony, Your Honor. This is a Court of Appeals case, February 335, Georgia Appeals 749, 2016. Again, basically just says that oral testimony can fill in the gaps of the written affidavit. And then again, Your Honor, we've already argued that the consent to search, which obligates the need for a search warrant, was not tainted by the protective suite. Same thing with this, Your Honor, under the independent source doctrine, that if they're going to get a search warrant anyway, so we're assuming that you find that protective suite was illegal. If they're going to get a search warrant anyway, and the search warrant was not because of something they found in the protective suite, which is what we have in this case. Janton said he went to his job was to go get a search warrant, and that was what his assignment was. He was going to the place to do the search warrant. So he was already in mind to do the search warrant before he was talked to the officers on the scene about anything they may or may not have found inside the house. So therefore, you would use the independent source doctrine under Tatum versus the state. That's a Supreme Court case, Your Honor, 2024. So it just came down last year, 319 Georgia Appeals 187. In that case, Your Honor, what they're saying is, as long as the search warrant wasn't gotten because of the illegal search, that what you would do is take out the things in the affidavit from the illegal search and go with just the things in the affidavit that he knew before that, and if there's probable cause, the search warrant stands.
So view this affidavit without the information obtained from the protective suite.
Exactly. That's what Tatum says. And but to get to that point, Tatum was trying. The reason the Supreme Court case was trying to go over two different tests that the 11th Circuit had. It was different from other federals, and went with the 11th Circuit. And so the first test is you have to say that the getting of the search warrant wasn't because they found something. You can't break into a place, find something, and that's why you go get a search warrant. That's not the case here. Since testified, he was already getting a search warrant. And if you look, those things are added at the end because he had already started his search warrant, and that was just added at the end. So you take those out. If there's still enough evidence, the search warrant stands. That's all I
That's,
Try to be brief, Your Honor. This is kind of what we learned. We understand that the deputy, the first person on the scene, had gotten information, but not really sure exactly what that information might be. He got information from his lieutenant. He went to one high school, nothing going on there. Then went to a grammar school, we understand. And then ultimately was told to go to this particular location. When he got there, immediately he did a protective sweep. The thing that is bothersome is this was not any active crime scene. There was no crime going on there. The cases that the state gave you, for instance, the Berry versus the state, not any relation to me. In that case, they came to, I think this was a probation warrant that they came there to see him about. In the case of Nelson versus the state, when the police got there, they heard a commotion going on inside the house. They were afraid other things were going on inside the house. So that was the reason that they made a protective sweep. In the Williams case, similar kind of situation. There was a standoff in that case at the house. So once that got resolved, it was certainly wise to do a protective sweep. But that's not what we really have here. We have an officer that really doesn't know what's going on. He's been given an address, and he says that he does a protective sweep. What we learned later is that not only he does a protective sweep, but apparently there are numbers of other officers who go into the house as well. So it's not really a protective sweep at that point. If you've got 3 or 4 officers going into a house on a protective sweep, obviously it looks more like a search. And we know that's what it turned into be because the deputy indicated that he saw a letter on the desk. And not only did he see the letter, he obviously read it because he gave that information to the GBI agent who was getting the search warrant. That's a search, not a protective search or sweep. It's a search. So that's the first problem that we have. The consent, as the state pointed out, if you would call it a consent, was not, those words were not spoken until after that protective sweep had already been accomplished. Just go on in. We don't know under what context that was said. Nobody ever got a written consent. Nobody indicated that they spoke with him. It's interesting too that nobody told the GBI agent that he even said anything like that. The GBI agent, based on only information, we asked him specifically, what information did you have before you got the search warrant? His job may have been to get the search warrant, but you can't just go get a search warrant. You got to have a reason. You got to have a probable cause in order to get one. Well, what was that? What was the probable cause? Who did you talk to? What information did you get in order to get a probable cause? Well, part of that information was I read a letter, and he referenced it in the search warrant itself. So the officer based his search warrant on information that was gathered in a search that was improper. It was an illegal search at that point in time. It was not a protective sweep.
If we assume, arguendo, that the protective sweep was bad, do you agree that that portion of the affidavit has to be excised from it in considering probable cause, or does that taint the entire affidavit?
Well, Judge, we feel like that information obviously should not have been given to the magistrate. If the magistrate used that in his decision to issue the search warrant, then the search warrant itself is bad. But if you give information that's bad in a search warrant, it invalidates it. I think we've all seen many instances where that occurred. So we feel like, due to the fact that the GBI agent was given information that was fruits of an illegal search, then that would invalidate the search warrant itself. Because the only thing that the agent was going on is what other people told him, because he didn't observe any of these things. So that, we think, would certainly be a problem. And I think, too, with most of the cases that deal with protective sweeps, I just wanted to be clear, deal with active situations that are going on at the house, like an active crime scene. This was never indicated to the deputy that this was an active crime scene, just go there. Apparently, he was not told what to do there. But when he got there, the first thing he decided to do was a protective sweep, along with all the other officers that went in. And I would adopt the argument as to the voluntariness also of Mr. Gray making the statement, just go in. We don't know exactly what context that is. We can't see everything that's going on in that video. We don't know whether somebody spoke to him. We really don't know much other than that one statement, just go in. Go into what? Go into the basement, go into the car. We really don't know. And we will adopt the argument as to the voluntariness of that particular statement. But based on these, and I don't believe any of the case law that the state gave the court really fit into this particular situation, because all of those were issues where there was something actively going on at that particular residence. They had no information that there was anything active going on there. They were told that there was nobody else in the residence anyway. So why do a protective sweep if there's nobody else there? Plus, why do you take so many officers in if it's not search? Thank you.
Does the defense have any case law you want to review?
No, sir, just the ones that previously mentioned.
Do you have any final word?
Real quick, Your Honor, going to the search warrant and the consent. Part B state, which I've already given you a copy of, just for the record, 308 Georgia Appeal 648. That's the one that said that even assuming the illegality of the initial search, so the text suite, assuming you should not have done it, a party's subsequent consent to the search, which is freely and voluntarily given, so subsequent to that, he gave his consent, freely and voluntarily, may serve as an independent act of free will that purges the primary taint and authorizes admission of the evidence. So if the evidence is found during this sweep, that it's illegal. A subsequent consent allows that evidence to be admissible. And in part, it means admissible at trial. But if it's admissible at trial, certainly it's also admissible in the affidavit for the search warrant. So even if you think that there's some sort of break in the chain because Bazinette didn't tell Yenta about the consent to search the house, the defendant's consent to Bazinette immediately coming out after the sweep to the person, one of the people that did the sweep, purges the taint of the sweep. So now that evidence that's found in the sweep can be used in the affidavit for the search warrant. Makes sense? And even if not, then you fall back on data.
All right, obviously important issues. I'll be prepared to render a ruling based on what's been submitted, but if y'all want to do briefs, you're welcome to do it. Up to you guys. No briefs?
I don't think we need to do brief sessions.
Okay.
Thank you.
All right, so I'll get your ruling inside the required 30 days. Then we need to talk about scheduling. We can do that. In chambers, anything else we need to discuss?
Not for the defense.
Okay. All right, we will adjourn for the day here. me make sure everybody is clear. So I know we have segments or portions of the video. Does anybody object? I wanted to watch additional portions of what was submitted. But I can't.
I just would encourage you, if you have time, to watch all of it.
No, 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 all right. Thank you. Council, y'all want to come to chamber? We can get back up and discuss scheduling.
Does that work? Yes, sir. Okay.
So watch this for a second. Go whilst I eat my Magnum. He's supposed to stop the camera, but he hasn't. Right. There you go. Sorry, I got a Magnum on eating. All right, hang on. Lee Dye. You did. Lee Dye sent me an email to say about Aaron Spencer. They're looking to continue push the trial down. So thank you. That just came out today. So both sides are looking for it to be extended from September. They didn't give a date, but that's the trial we'll be looking at. And if you've not seen it, please go and watch it, whether you watch one of my videos or whoever else. That's an important case. So this one's going to be bizarre because from what I'm learning, there's no necessity to lock up guns in Georgia, which I think one is ridiculous, but two is, but also I'm not a gun guy, so what can I say? So there's no law backing any of this up. Then let's look at this. Hang on, I'll get this up for you now. Let me get this up for you guys now. 2 seconds. This happened 8 days ago, so I'll play this here. Where is it gone? There. Yeah, they didn't give a date, but probably they just need a court. That's what she said. That's what the court. So here we go. This is more info about the trial.
Welcome back. The court date for the father of Colton Gray, the teen accused of killing 2 students and 2 teachers at Apalachee High School in 2024, has been pushed back.
That's right. So if you recall, Colin Gray was indicted last October. He was accused of applying his son Colt that gun used in that horrific attack. And our Chase Howell, he read through these court documents. He learned the move all boils down to scheduling conflicts here.
In September, it'll mark 1 year that the small town of Winder, Georgia, endured the unthinkable after police say Colt Gray, who was 14 at the time, shot and killed 2 of his classmates, along with 2 teachers. His father, Colin Gray, still awaiting trial with no new court date in sight after a Barrow County judge approved the defense's request for a continuance.
I just think that it just sends the wrong message to the students and the parents and grandparents and people that lost someone.
According to court records filed on Monday, the defense asked for the continuance because of the conflicting trials in Fulton County during Colin's original jury trial set for September 8th.
The biggest thing that underlies the court system, or the biggest hurdle the court system faces, is logistics.
Lawyers can only be in one courtroom arguing one case at a time.
Brandon Bullard is a criminal defense attorney throughout Metro Atlanta. He says the continuance also has to do with checking the state's availability. And with the courts having to pull jurors from Hall County to ensure a fair trial, it has to reschedule the jury selection process.
There are complexities dealing between the courts in two counties. There are the complexities with the lawyers having to review the jury lists and getting those lists from the opposing county or from the remote county. And then there are all of the complexities of the lives of the jurors who might get called into this case: work, family, vacation, medical. So it's just a lot to manage across the board.
In May, Colt's lawyer told us they were eyeing a plea deal that they may take at his court appearance in October. But with Colin's trial being rescheduled, we could also see that be delayed.
If a co-defendant, if Colt comes in and says bad things that are bad for his father in his father's trial, his father would have the right to put in front of the jury the details of any agreement he had with the state. The state avoids that evidence by deferring Colt's plea date so that there is no concrete benefit.
Now, I asked Bullard if it's unusual to see a case not go to trial nearly a year after the indictment. And he says with a case this complicated, it's not as unusual as you may think. But for those in Winder, they just want to put the tragedy that happened on September 4th, 2024 behind them. In Barrow County, Chase Howell, 11 Alive News.
All right. Here we go. So hang on. Right. Can you imagine someone breaks into your home? No, I would hate that. And breaks into your home and you ask them to wait while you, I don't know. I don't, like, I am sitting here with no judgment. I have no clue about, I feel very naked. And you know that, anyway. Those of you who are regulars know why I feel naked when it comes to these guns and stuff like that. I'm just not we need to get Mighty Meat on here. But that's a very good point as well. Around weapons, I personally don't think it's a weapon problem, but a people problem. Popular opinion, I'm sure. But I like my Second Amendment. There you go. Only the federal laws apply in GA proper storage. Wow. There you go. So that makes a difference about why he's been charged, you know. Find court documents. I found all kinds, but these. I agree with you. There you go. Mexi Taxi and popular opinion for me, MAGA equals. Right, there you go. Just lady died to bring that up. Kids familiar with firearms are safer than those who are not. So I don't think Mighty Meat will mind me saying this, but Mighty Meat, you know, takes his children, trains them, makes them understand how they work and stuff like that. They're like 10 and 12 or something. So yeah. I was one of them, and my kids partook as long as they were interested. However, I never assumed I should leave my weapons out for my teen Steves alone. Go. I have never heard that lady die. It's a mental health issue. Look at New York that has strict gun laws. Yeah, I don't disagree with that. I do not disagree with that either. We'll have a new saying now. Very much a handmaid. Yeah, I agree, Cara. Mary, depends where the family lives. Some need access for several reasons. Agree, but what we are talking about, a shotgun with 2 slugs in it behind the door. I live in Bear Country. They are good reasons for needing a weapon. The feds aren't charging them, are they? I thought the state of Georgia was. It is the state of Georgia, yes. The Constitution is written to protect us from the government tyranny, and they're slowly trying to push and push. So he's got a sleuth of charges. We read them. Sleuth of charges against him. He's been... we read them out, didn't we? Where did I put him? Where is it? Is this the one? Let me just see. Okay, no, that's not that one. I'll see that he had like 20 plus. Oh, here we go. I think this is the one. I think this is the one. So he's facing, well, this was September last year. Colin Gray, 54, is facing 4 charges of involuntary manslaughter, 2 counts of second-degree murder, and 8 of cruelty to children. That's baffling to me that he's facing all those. You know, that is baffling. The 2 counts of second-degree murder. I mean, I in my mind, I can understand that bit. So there you go. Georgia state law allows prosecutors to charge minors from the age of 13 as an adult in certain crimes. So he will be charged probably as an adult, and Colt will, because he was 14 at the time. Okay, so that's what that is, and some of his So yeah, there's a debate. Wicked said about whether it's civil or not, and obviously Colt did what he did. He deserves to be put on for murder, and throw the book at. The discussion here is about whether the parents are liable or not. On a civil case, I agree, they are 100% liable. It's whether they're liable for murder too. I personally don't think that they should be charged for that. Civil is definitely different from yes. And so if he's charged as an adult, how can they charge the father? Well, that's another question, isn't it? I don't think there is a answer to that. They definitely could file a civil case against him if they have enough evidence. There was negligence. This is not for criminal court to decide. I think that's very sensible. I think I land where Wicked is. I don't believe that it is for criminal accountability. Yeah, I don't think it is a criminal trial personally. Again, I'm not. I do get the line of where do you draw the line of it, but there's responsibility, and I think, as you say, in a civil court, they will be done for negligence of sorts. But you try and Colt as an adult, he's going to get a book thrown at him. He's going to have life in prison without parole. I mean, yeah. They did the same with the Crumley. I didn't follow it. I followed it, but I didn't watch it. I'll be honest with you, maybe I was naive, but I was like, there's no chance that they were going to be found guilty. It was like, how can you charge and find them guilty? But then they were. I was like, what the what? I thought it could charge either way. I think they can, but yeah. 14. I think he was 14, Cara. I think he just turned 14 from what they're saying in the papers. Kid that my parents had no clue about. Exactly. Yeah. The trial for this is definitely, yes, criminal. I think if he wasn't 14, he was close to being 14. So he might have been 30, he was on that cusp, whichever one he was. Yeah, I didn't watch it, for being honest. Charge. No, that's not what I was saying. Sorry. What I was saying is that Bad Daz has said, how can they be... Yeah, he makes sense to me. So Bad Daz has made a good point saying, if he's charged as an adult, 14-year-old is charged like an adult, why is the father then charged as well? Because you are charging a 14-year-old as an adult, fully responsible for his actions. So then you say that he's an adult, fully responsible for everything. However, we're going to charge another adult for being irresponsible. I was saying that I was agreeing with Bad Daza that it shouldn't be the case. It doesn't make sense. You did. The school was more responsible in the Crumley cases. Okay, again, I don't know. In my opinion, the only responsible in the Crumley case was the child. The Crumleys were following what the school council suggested. Okay. They were visited by Ellie prior to the incident. I don't know if they have a case otherwise. Yeah, so we watched that, didn't we? We watched that one where they went there. It wasn't like, they turned up without much of a. They just turned up and said, "Oh well, possibly there's a Discord account, and your son may have possibly, or somebody from your house possibly sent a message that they're going to shoot high school." They didn't really take it seriously, and they spoke to Colt in front of the father, and I think the father probably spoke to him and thought that was the end of it. He was like, "No, I never did it." So again, and that was through the FBI. That's a bit shoddy that the FBI didn't know a lot more than they did. Do you know what I mean? About where it was, who wrote it, because there was no evidence of it that the police officers had. It was all hearsay. They had nothing. It probably did happen, but that was really shoddy, to be quite honest with you. The commission should be overturned, but it's in Michigan, right? Yes, it's Michigan. No, that one's Michigan. This is Georgia. Yes. Right. Was there anything else on this one before I look at it? High school crew. Yeah, pushback, trial pushback. Yeah, I thought there was coming back today that there would be a. Right, do we want to watch this then? I would preface this by saying this is law and crime, so careful. But let's watch this. This has got 12 disturbing details of Georgia. No worries, Mary. Thank you, Medallion, and thank you for your opinions and stuff like that. I'm still learning. Like, I don't deal with guns and stuff, so I'm learning as I go along. So I'm very naive. No problems at all, Cara. Thank you guys for being here. For those of you that don't know much about this case, I'm going to play this law and crime thing. It says 12 details of Georgia school shooting and suspect Colton Gray. So this might give us a little bit of insight. So I appreciate those that might be leaving. Thank you very much for being here. I do really appreciate you. Please give a like on the way out. I would really like that. And those staying, strap it in and we'll watch this one, Law and Crime. But take it with a pinch of salt. Just remember, mainstream media, not the best, people. I agree. I think it brings up really good conversations for that we can all learn from. I think that there's no 100% right in some of these things. I'm just absolutely shocked. There's so little laws in all these in Georgia. Right, here we go. Right, you strapped in. Here we go.
His charges are directly connected with the actions of his son and allowing him to possess a weapon.
A teen and his father are both behind bars after the country's latest school shooting left 2 students and 2 teachers dead. It happened about an hour outside of Atlanta in Winder, Georgia. The 14-year-old alleged shooter made his first appearance in court, accused of using an assault rifle to target his classmates and teachers. We have the latest information from police reports, court records, and witnesses. Welcome to Sidebar, presented by Law and Crime. I'm Elizabeth Milner, in for Jesse Weber. 14-year-old Colton Gray appeared in court in person on Friday to hear the charges against him, 4 counts of felony murder.
If you have any questions about these charges, then I would urge you to discuss those with your attorney. I would invite you, Mr. Harmon, to inform the court as to whether there's a request for bond at this time.
At this time, Your Honor, there is not a request for bond. We will file the appropriate motions if that becomes necessary.
All right. An indictment by the grand jury for most felony offenses or accusations. Well, you have the right to receive an indictment for these offenses. And I assume Mr. Brad Smith is here on behalf of the DA's office, or he is our district attorney. And he's accompanied by Ms. Patricia Brooks, who is his chief assistant. A preliminary hearing, you'll have the right also to a preliminary hearing unless you make a bond, which of course at this point there's no bond being requested, or unless you waive such a hearing. You have the right to a speedy and public trial by a judge or jury. You have the right to confront and cross-examine all witnesses. You have the right to call witnesses on your own behalf and testify in your own defense if you so choose. As you sit here in this courtroom today, under the law, you are presumed innocent. Your refusal to testify at any point in any proceeding will not be used against you in determining whether you are guilty or not guilty. Counsel, let me just inquire as to whether there are any other items that the court should address before we conclude this preliminary hearing.
No, Your Honor.
No, Your Honor.
Well, I do have one piece of information to convey to the court. There was a development yesterday afternoon that makes it necessary for our office to have alternate counsel appointed, and arrangements have already been made in that regard. I've already explained that to Mr. Gray, and alternate counsel will be appointed by the end of the day today.
All right, thank you very much, Ms. Donna C. Graves. All right, then with that, this hearing is concluded, and you may escort this defendant out.
After a brief recess, the judge brought Colt back into the courtroom to clarify some things.
All right, Mr. Gray, we visited a moment ago. I just need to correct a couple of things on the record. I correctly told you the maximum penalty for the crimes for which you are charged. That's correct, except for the fact that you are under 18 years old. So I wanted to inform you and make it clear to you that the penalty for the crimes for which you are charged does not include death. It includes life without the possibility of parole or life with the possibility of parole. I also wanted to inform you that the court has set December 4th at 8:30 a.m. For your preliminary hearing. And that is, of course, subject to change as you secure new counsel later today and so forth. Is there anything else that needs to be addressed that anyone can think of?
No, Your Honor.
No, Your Honor.
All right. So with that, you may escort Mr. Colton Gray back out. Thank you.
A few minutes later, Colin Gray, Colt's father, also appeared in court. He seemed emotional and rocked back and forth in his seat as the judge read the charges and the penalty he could face if he's convicted.
For you, why don't you just state your name, please? All right, pull the microphone down, please. There you go. All right, and how old are you, Mr. Gray?
54.
And are you able to read and write and understand the English language without
Yes,
any
sir.
difficulty?
Yes, sir.
How far did you go in school?
11th grade GED.
Okay. All right. So the following aren't questions that I'm going to ask. I'm just informing you of some things. You have the right to remain silent. Anything you say can be used against you at further hearings or at a trial on the charges that you're facing. For this hearing, you're not going to be questioned about facts and circumstances surrounding your charges. You are currently charged with, and you'll be provided with copies of the warrants if you don't already have them. You're currently charged with 2 counts of felony murder in the second.
Sitting in as counsel for Colin Gray also did not seek bond on Friday, opting to have his future court-appointed counsel file a motion at a later date if they want. For now, he's scheduled to be back in court in December. I want to thank Morgan & Morgan for sponsoring today's Law and Crime YouTube Takeover. The stories we cover here on Sidebar and Law and Crime are very tough, and it shows that the world is an unpredictable and at times very scary place. So if you're ever hurt, it can be scary and confusing, especially if you don't know where to turn. But Morgan & Morgan, America's largest injury law firm, can help. This is a team with more than 1,000 attorneys you should want in your corner, and there's a reason they're America's largest injury law firm. They win a lot. In the past few months, they've secured multiple multi-million-dollar verdicts that were actually considerably higher than the highest insurance offer. And we're all on our phones so often that Morgan & Morgan makes this whole process so easy. You don't even have to leave your couch. From submitting your claim to uploading documents to signing contracts, it can all be done from your phone in 8 clicks or less. So if you're ever injured, you can start algebra class around 10 a.m. and came back to the classroom with uploading documents. So easy. You don't even have to leave your couch. From submitting your claim to uploading documents.
Sorry, I was making coffee.
To signing contracts, it can all be done from your phone in 8 clicks or less. So if you're ever injured, you can start by easily submitting a claim at forthepeople.com/YouTube takeover. So here's what we know so far about what happened on Wednesday, September 4th. Witnesses say the shooter left his algebra class around 10 a.m. and came back to the classroom with an assault rifle his father reportedly gave him for Christmas. When he couldn't get back into his math class, witnesses say the alleged shooter went to the classroom next door. That's when he allegedly opened fire, killing Mason Skirmerhorn and Christian Angelo, both 14 years old, and teachers Richard Aspinwall and Christina Urami. School had only been back in session for about a month. 9 other people, including 8 students, were injured in the shooting and taken to a hospital. Fortunately, all 9 are expected to be released and make a full recovery. 2 school resource officers confronted Gray, according to Barrow County Sheriff Judge Smith, and he surrendered, putting the gun on the ground. After he was read his rights, he reportedly made a chilling statement: "I did it." Arrest warrants for the alleged shooter charge him with 4 counts of felony murder. For now, he's being held at a youth detention center, but he'll be tried as an adult. According to authorities, Wednesday was actually only the shooter's second day at Apalachee High. He was a transfer student who had only come to the school for part of the day on Tuesday. Sheriff Judge Smith told CNN that Gray had left class on his first day to visit the counselor's office because he was having anxiety. The next day, he was only in class for about 30 minutes before the attack. Heartbreaking text messages have been posted on social media showing conversations between students inside the building and panicked friends and family outside. Aaron Clark posted a text thread showing the messages: "School shooting right now. I'm scared. Please, I'm not joking." A response: "Where are you?" Class: "Someone's dead." Just one day after the shooting, 54-year-old Colin Gray was arrested in connection with the shooting. As you heard, he's charged with 4 counts of involuntary manslaughter, 2 counts of second-degree murder, and 8 counts of cruelty to children. The Georgia Bureau of Investigation says a brand new emergency alert system saved lives during the shooting. The new technology was just installed last week. Several teachers were also able to press buttons on badges to call for help and put the school on a hard lockdown.
Please lift up our community. Please keep these children, these teachers. We call them teachers, but I call them heroes. We met with them today. Emotions are very high, obviously, but we told them that we love them. We love our teachers and what they do. And we're very happy at the fact that they stood in the gap between evil to protect their children. And we want to include them in the lives that were saved as well yesterday. We're heartbroken. A young person brought a gun into a school, committed an evil act, and he took lives, and he injured many other people, not only physically, but mentally. But I'm proud of Barrow County. I'm proud of our superintendent. I'm proud of these teachers. I'm proud of these schools, and I'm proud of where I live. And we'll get past this. You see behind me, up here on the hill, we got a vigil going on at our flagpole. I welcome you to go see those kids and those young people that are hurting.
We want to talk about the victims in the shooting. 14-year-old Mason Skirmerhorn had recently started at the high school. His mother says he was living with autism and could be easily spooked. There were searches for Mason and all the chaos on the day of the shooting, with his family hopeful that he was hiding somewhere. But they soon learned he was actually one of the victims. A family friend told the New York Times he really enjoyed life. He always had an upbeat attitude about everything. 14-year-old Christian Angelo was also killed. His sister wrote on a GoFundMe page for funeral expenses, "He was loved by so many. His loss was so sudden and unexpected. We are truly heartbroken. He really didn't deserve this." The 2 teachers who lost their lives were both math instructors.
instructors. 39-year-old Richard Aspinwall was also the high school football team's defense coordinator. The husband and father of 2 little girls is being remembered as someone who is kind-hearted and hardworking. 53-year-old Christian Arami, an algebra teacher, also died from gunshot wounds. The native of Romania was active in the Romanian community and worked as a dance instructor. She was actually celebrating her birthday on the day of the shooting. A friend told CNN she decided to bake a cake and bring pizza to her class the day she died so she could celebrate her birthday with her kids. GoFundMe pages have been set up for each victim's families. Several of the surviving victims have also been identified. Taylor Jones was life-flighted to Grady Memorial Hospital, a level 1 trauma center in Atlanta. She's listed as being in stable condition. Her family didn't say exactly what her injuries were, but said she will have to undergo more surgeries and physical therapy. David Phoenix was another math teacher in part of the building where Gray allegedly opened fire. Witnesses say when they heard loud banging sounds, Phoenix went to open the classroom door, and that's when he was shot. Another teacher was able to scramble to the door and shut it. Phoenix's daughter wrote on Facebook that when David woke up from surgery on Wednesday, he immediately wanted to know if everyone else was okay. He will also need additional surgeries, but is expected to recover. So what exactly was the motive behind such a destructive and heinous act of violence? That's what investigators are trying to figure out right now. It appears Gray had a troubling home life growing up. He was living with his father, Colin, while his mother, Marcy, lived with her parents hours away in Fitzgerald, Georgia. Gray's mom, Marcy, has a criminal history dating back to 2007. She was sentenced to jail last December, around the time it's believed Colin Gray bought his son an AR-15 style rifle for Christmas. In December, Gray pled guilty to counts of using a license plate to conceal identity, damage to property, and trespassing/family violence. Marcy was sentenced to 5 years in jail, but only served 46 days before she was released on probation. She had to take part in a family violence intervention program and not use drugs or alcohol. But then in April of this year, Marcy was charged in connection with a case of aggravated battery of a 73-year-old woman. She allegedly threw the woman against the wall, broke a mirror in her home, and tied the woman's hands and feet to keep her from leaving. She reportedly has not yet been indicted in that case and was released on bond. Marcy has previously said on her LinkedIn page that she was a victim of domestic abuse at the hands of her husband, Colin. Court records show she had been banned from contacting Colin Gray without some sort of third-party intermediary being involved. A neighbor who lived next door to the Grays at their home in Jefferson, Georgia, back in 2022, said she would hear screaming and yelling all the time, and that sometimes Marcy would lock the children outside. She also claimed to the New York Post that she would sometimes find Marcy passed out behind the wheel of her car in the driveway. Neighbors near the Grays' current home in Winder say they mostly kept to themselves. The Atlanta Journal-Constitution reports that Marcy Gray was sued by a Chevrolet dealership in 2019. She reportedly bought a Chevy Suburban using a $10,000 check as a down payment, but the check bounced. Marcy was ordered to pay the dealership around $19,000, which included the money initially owed, plus interest and attorney fees. As news started to come out about the shooting at Apalachee High, the alleged shooter's aunt and Marcy's sister, Annie Pulhamus Brown, started writing on Facebook, and her post immediately went viral. A now deleted post said in part, quote, "I am not scared. I will not back down. I will not disrespect other parents and families that are dealing with this tragedy on the opposite end. They did not deserve this. With that said, I will not leave my nephew standing alone. When Uvalde happened, I told my own children only hurt people hurt people. I did everything I could to fight for my nephew. I will take care of my nephew and what he needs on this side. Just check yourself before you speak about a child that never asked to deal with the BS he saw on a daily basis." Pulhamus Brown was immediately condemned by people in the comments, and she soon deleted the posts. Meantime, within hours of the school shooting on Wednesday, the FBI's Atlanta field office released information about school shooting threats made in May of last year that were connected back to Colton Gray. We got our hands on the Jackson County investigative report about the conversation between deputies and Colt, as well as his father, Colin. The FBI had gotten a tip that someone planned to shoot up a middle school the next day. The info came from a user on a Discord chat. Discord is an online platform mainly used by video gamers to live stream. Investigators were able to connect the account to an email address linked to Colt. I responded to this address and spoke with Colin Gray and his 13-year-old son, Colt. Colin stated that he does not know what Discord is, stating that he works full-time and does not play video games. Colin allowed me to speak with Colt. Colt stated he used to have a Discord account, but deleted it prior to moving from their previous address. Colt expressed concern that someone is accusing him of threatening to shoot up a school, stating that he would never say such a thing, even in a joking manner. Colin informed me that he does have firearms in the house, but that they are hunting rifles. He stated Colt is allowed to use them when supervised, but he does not have unfettered access to them. This was prior to Colin allegedly purchasing a rifle from Colt for Christmas last year. Investigators linked the school shooting threat to multiple IP addresses all over the country. Because that exact source of the threat couldn't be identified, neither Colt nor Colin Gray were detained. The sheriff's office report states, at this time, due to the inconsistent nature of the information received by the FBI, the allegation that Colt or Colin is the user behind the Discord account that made the threat cannot be substantiated. This case will be exceptionally cleared. As law enforcement dealt with the mayhem and uncertainty surrounding the shooting at Apalachee High School, other North Georgia school districts were dealing with threats of their own. In one case, Gainesville police arrested a 14-year-old, charging him with making a terroristic threat and disrupting operation of a public school after an alleged threat started circulating on social media. Officials in Athens, Clark County also announced they had a person in custody for hoax threats, this one a 12-year-old. They say he posted photos of guns he found online and listed names of schools. There were rumors in the hours after the attack that there was more than one shooter and that they planned to target as many schools as possible. In fact, another teen in Jackson County, where Colt Gray lived until recently, was heard saying on a school bus that he planned to, quote, finish the job. Deputies tracked the student down and arrested him. He's now in the same youth detention center as Colt. The sheriff said those rumors were unfounded, and it appeared Colt Gray was the lone perpetrator. A second vigil is planned for Friday night at a park in Winder. Grief counselors are expected to be there to help anyone who might need it. Of course, we'll continue to follow this case closely and bring you the latest. That does it for this episode of Sidebar. You can watch more episodes and subscribe to us anywhere you get your podcasts. I'm Elizabeth Milner, and this has been Sidebar presented by Law and Crime.
Okay, that's quite interesting. There's a few things there that we can look at. I think there's a lot more research needed to be done here. There's a lot of stuff. The mother, whoa, okay. Right, as I just wrote in there, I have set up another stream. I want to keep it separate. So there's another stream for the Brian Walsh pre-trial hearing. It's already started. I'm going to start it fresh. So those that want to join, you should be redirected to it. If not, let me put the link in here just in case. And we'll go over there. This will be quite interesting today. It's been a good conversation. I've enjoyed this stream, everybody. Thank you so much. It's been good. So this is this a link? I think so. Just in case it doesn't redirect. But yeah, it should be redirected. So yeah, I shall see some of you later. If not, thank you for being here. Really, really, really appreciate that. And yeah, I shall see you on the next stream. If not, see you another time. Take care, everyone. Thank you. Goodbye.